having difficulty with your microphone. I don't know if it's a technical problem, but you're coming in and out. It's cutting you off.
I'm probably moving my head.
Oh, okay. All right.
Can you hear me now?
I can hear you. It's just that sometimes it cuts you off. I can continue, and if I see the problem again, if it occurs again, I might have to disconnect and have another coworker assist the courtroom. It could be with my system. I'm not sure.
Okay.
We'll continue and see how it goes.
Thank you. All right. Is this Mr. Bueno Beltran? Sir, thank you. Case number is 2021 MM 3313AO. And the allegation is domestic battery. Okay. And it appears that you filled out a public defender form and that you do qualify. We will appoint the public defender to represent you. You should get some information on how to make contact with their office and make an appointment. Find out how to deal with your case. There was enough information to find probable cause for a charge of domestic battery. It's going to Division 50. I don't think I saw this one. And there's no witness here in regard to that?
No, Your Honor.
Thank you. Okay, there's enough information for the charge to be filed. And because the witness is not here, and a judge has to hear from the witness before you're allowed to have contact, we would order no contact right now. Talk to the public defender about getting a hearing about that. Separate residences for now. If you need police escort to get some things out of the residence, then you can get a police escort. And the bond, normally on these misdemeanor batteries, I think would be about $500. Did I leave out any conditions?
They would also ask for no weapons, firearms, or ammunition.
All right.
And would also ask for no alcohol without a valid permission, because there was also an allegation of drinking.
I'm sorry, Your Honor. I'm having difficulty understanding the state attorney. I think if she could get closer, her voice is also cutting off.
The state would also request no weapons, firearm, or ammunition. It would also request no alcohol or drugs without a valid prescription, as there was an allegation of alcohol use in the affidavit.
Okay, thank you, Counselor. Sir, those are fairly standard. We'll put those on the paperwork for you. If you bond out, make sure don't have the contact unless and until you've talked to a judge, and you should be able to get a hearing quickly if you need that condition to be. Talk to your public defender about that. All right, good luck to you, sir. And make sure you attend all your court dates.
I'm sorry, Your Honor, before we continue with the next one, I would request if I could please hang up and have you call and have another team player, another interpreter assist. I'm having difficulties hearing what's going on.
Okay, no problem. Thank you.
Thank you.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Has everybody been sworn? Is that your question?
No, that I have already been sworn, Your Honor.
Oh, thank you. Okay. We started with our interpreter cases, but we had a bad connection, so let us know if that continues to be a problem.
Okay, so far so good.
I think we only have one more person. Okay. Oh, so this would be Mr. Bautista Contrero, correct?
Sí.
Okay.
Yes.
Thank you. And the so we have some traffic charges and also a first appearance detainer. We go ahead and start with your detainer, if nobody minds. Evidently, you might have been out on bond for a DUI, case number 2021 CT 61680. And when you're out on bond and you get a new charge, it's considered a violation of your bond conditions. So we have to consider that. The new charges are case number 2021 CT 443. I think it says AA would be a POPTA, and 2021 CT 444. And those are alleged to be driving without a license and also driving under the influence. Let's see. First, let's go ahead and see about the public defender. It appears that you would qualify for the public defender. Will appoint their office to represent you, sir. It appears they have enough information for the new charges, the DUI and the driving without a license, sir. I'm not sure why they. Folks, I might be relating to some of the older bond schedules. Because I'm used to the DUI being 500 and then the no valid being 100, notwithstanding the bigger problem is that he's out on bond, but I'll go ahead with those bonds.
Yes, Your Honor, usually a DUI is 500 due to
Right,
being
for some
a
reason, the
M1.
officer he doubled it, probably because he might have ascertained that Mr. Bautista was out on bond.
And it's a higher level DUI.
Oh, because of the 0.3.
0.15. That's why the
Okay.
bond is higher, but it's within your discretion if you would like to.
Be under the discretion.
Yeah.
Okay, all right. Okay, now, sir, in regard to the fact that you were out on PTR or bond on the other charge, the older one, we would revoke the pretrial release. And that's a pretty high breath alcohol level, I would just say. You're in danger of hurting yourself or others. So let's go ahead and put 1,500 on the old DUI. Public defender, sir, I think it's obvious that you should not be driving. The state's going to ask for a no alcohol order. If you want help, because you're obviously at a crossroads in your life, whether you're even going to survive or not at that alcohol level, you might want to try Alcoholics Anonymous. You can go every day. And I've seen it save a lot of people's lives. They don't have any real treatment to help you with at the moment. I don't think we still don't make provision for that.
Right.
But Alcoholics Anonymous, you're in a position where you're basically going to die if you don't get control of the alcohol.
Your Honor, just to be clear, for his out on bond, the 21 CT 616, you revoked and set it at 1,500.
Yes, ma'am.
Regarding his bonds on his new case,
I couldn't hear the last.
regarding his bonds on the new case.
Oh, the new ones I set at 500 and 100,
Okay.
even though it's a high alcohol level. Good luck.
May I ask a question?
You have the right to remain silent. Anything you do say could be recorded and played back at a court proceeding if you accidentally incriminate yourself. But we will give you information so you could call the public defender's office.
Madam Interpreter, I did provide a green sheet with our telephone number on there. If he has any questions, he can call that number. But I would recommend him not talk about the facts.
Did you have a? Turn it down. Did you have a question that's not related to the facts of your case, sir?
No.
Okay, call your public defender then in regard to your question, and good luck to you, sir. I think those are all the interpreter cases. Thank you, ma'am.
Thank you, Your Honor.
Okay. Right. Would this be Ms. Doyle, correct? Okay, thank you. So, ma'am, the charge is 2021 MM 326580. The allegation is trespass, and you might have been out on bond for a battery and fraud impersonation charge. In regard to the new trespass, let's go ahead and appoint the public defender's office to represent you, and you should be getting information on how to call them.
Yes, Your Honor. I would ask that you take no action on the out on bond. We can't plead this one out because it seems that there may be some competency issues.
Oh, okay.
So I'll just ask that you set a bond and take no action on the out on bond.
Also in regards to Ms. Doyle's out on bond, we haven't filed on it yet, so state also requests that you take no action.
You also request what?
That you take no action. We also haven't filed on her out on bond case yet.
Okay. All right, I'll go ahead since both parties are in agreement. Do we still have something called mental health pretrial release? Is that a thing that we still do?
Yes, Your Honor, you can ask that she be screened for mental health PTR, and then in the alternative, if she is not approved for that, set whatever bond condition that you deem
Okay, because I don't want it to keep her in jail. So there's an alternative, okay. Okay. Ma'am, there's enough information for them to file a charge on the new trespass case. We're not going to revoke your bond on the old one. We realize that you might have some mental health considerations that would mean that we should give you a little bit of a latitude in regard to that charge. So you still have that same release conditions plus an alternative, either a $500 bond or mental health pretrial release if you qualify. And what that program is, it might actually give you some services, some medication, some help if you're interested.
Your Honor, state would also ask for a no return to the Walgreens
Oh.
located at 190 South
Oh.
Orange.
All right, and no return to that particular Walgreens, okay. Good luck. Next, we're calling up Mr. Felipe Francillo. Okay, and you've got, the new case is 2021 CF 5556 involving an allegation of petty theft with 2 prior convictions, sir, which makes it into a possible felony charge. They do have probable cause. I don't think I have a public defender form attached, but he already had the public defender for the case for which he is out on bond. Can I just appoint a public defender then, based on that? Okay. All right, so the new charge, they have enough information to file it, and I think that the normal bond amount might be $1,000 on the felony petty theft and $100 on the resisting. Like I said, my memory of the bonds might be old, but hopefully it'll work for today. And also, you were out on release on own recognizance on a trespass charge, which was 2021 MM 2426AO. In regard to that, sir, I'll go ahead and revoke the bond and, or the ROR, and set that one at 500. It is a violation of your release conditions on the other case to get a new charge. I think in the past it used to be 2,000, but based upon all the circumstances, I put it at 500. Now, we'll appoint the public defender on the new charge, and I would suggest to you, sir, now that you're being bumped up to felony court, you might be better off talking to a public defender.
Your Honor, state would also request no return to the Walmart.
Okay, no
contact with
return.
victims or witnesses.
No return to the Walmart. Thank you for reminding me of all the standard release conditions. Thank you.
Of course, Your Honor.
It's been a few years. Good luck. All right, is this,
Joseph Hampton is mental health.
okay, so we'll reset him, I guess, for tomorrow. Right? Okay.
Your Honor, I'll waive his appearance, because I believe this is the second time he has not been able to appear. I'll
Okay.
just waive his appearance today, Your Honor.
All right, so we'll go ahead and appoint the public defender, if we haven't already. And public defender has waived his appearance, and he was on probation, state probation before this case, I think.
Yes, Your Honor. And 19 CF 8075.
Oh, excuse me, if you, just think of me as a really old lady and I can't hear, that would be helpful, because it's probably getting to that point.
Yes, Your Honor. He was on probation and 19 CF 8075. I
Right.
ask that you hold him no bond on that case.
Okay, no, that we didn't have any paperwork from the probation officer, but we're just going to do the on-view VOP. Is that what you're asking for?
Yes, Your Honor. The officer filed an on-view.
Oh, okay. Oh, let's see where that is. All right, and so, okay, that's right, the on-view. So we'll do the no bond on that. And set bond in regard, find probable cause and set bond in case number 2021 CF 5686 at 2,500 on the battery Leo, 150 on the resisting with violence, 100 on the resisting without violence, and We'll let the lawyers deal with that down the line. Thank you.
Your Honor, I believe he has one more case. There's 3 total cases. I believe he has
Oh,
one more.
that's right. I did run through that, didn't I? Okay, let's see where that is. Okay, right. The other one was the criminal mischief. That's case number 2001 CF 5688. We'll find probable cause on that, set bond at the 1,000 on the criminal mischief and 100 on the battery. Thank you for reminding me of all
Yes,
these.
Your Honor. And can you order a no return and a no contact with victim or witnesses?
Okay, so ordered. Thank you. All right, the next person, is this Miss Kenisha Price?
Yes.
Okay, thank you, ma'am. Trouble with these dummy barcodes. Okay. Ma'am, you got arrested on a failure to appear warrant in case number 2002-1 CF 242380 and possession of drug paraphernalia 2002-1 MM 330780. The felony, you were out on bond for $1,000. In regard to that case, Judge Blackman, Division 10. And the new charge, possession of drug paraphernalia. They have enough information to file the new charge, possession of drug paraphernalia, and we'll go ahead and appoint the public defender in regard to that case. And revoke the bond in regard to the old case, but set a new bond of $2,000 on that. And I recommend you call your public defender to
I'm sorry.
handle everything. And you've got court dates in both felony court and misdemeanor court. That can be confusing.
You said you were going to set the bond on the FTA at 2,000?
I think the judge already said it. Well,
At 1,000.
at 1,000, Your Honor.
So I didn't hear what everybody said. You're questioning whether I put it at 2,000 and because it came in at 1,000?
Yes.
Yes, Your Honor. It didn't come in as like an out on bond case since it's a failure to appear when the judge signed that warrant, set the
Oh,
bond at 1,000.
he put 1,000?
Yes, Your Honor.
All right, thank you. Well, that's fine. We'll go with 1,000. Okay.
And were you leaving the bond on the misdemeanor case? On the drug paraphernalia case?
At 500? Yeah. Okay.
I'd ask for a condition of that bond to be no drugs or alcohol without a valid prescription.
Okay. I just feel better about it if we had a way to, really help her out instead of just like, she bonds out and she's got the same problem. So, but, we'll tell her not to do it again.
Yes, Your Honor. On this stage, that's all that can be done. Things can be done further down the line in the trial division.
Good luck, ma'am. Okay. Mental health, in other words, she can't come to court today, is what you're saying? Okay. All right. Okay, thank you very much. Let's see, would you go ahead and raise your right hand to be sworn in? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you very much, sir. You can put your hand down. Could you tell us your name for the record?
Keith Darnell Bryson.
Okay. And you already looked like you were here before.
Yes, ma'am. I came yesterday, and it's the same reason they reset. And I'm here because it's a big misunderstanding. My girlfriend, she needs help with leg side, and that's what I tried to get assistance with. Unfortunately, she got arrested. You understand?
Yep.
I know she's off her medication. I know this, but being in here, they don't know that. And right now, she probably feel like nobody's here for her, and I am here for her. So that's why I'm here again, because I want to try to do the best to help her.
All right.
Because
So,
she didn't have a bond. I'm trying to get her out of here. I couldn't get her out of here yesterday. And I'm trying to get her, because if she get out right now, I'm going to be the one to take her to Lakeside person and make sure she gets back on her medication.
okay. So yesterday you said that you just wanted no hostile contact.
Well, I mean, that's what I'm saying, ma'am. I'm saying the same
I
thing
understood what
today.
you're saying, but-
I want contact with her.
Right. I was just clarifying that.
Yes.
Because you did say it yesterday and the notes were in the record.
Yes.
I think
yes.
we all understand.
And
the other thing
I would be the first to call
Right. So you're
police
asking
if I have to.
for
But
her to get a bond and to be let out.
yes, ma'am.
Okay. State any concern about that?
Your Honor, can I have the witness a few questions?
Oh, sure.
Good morning, sir. You said your name was Mr. Bryson?
Yes, ma'am.
And what is your relationship to Miss Thompson?
She's my girlfriend.
Okay, approximately how long have you known her?
Over 10 years, ma'am.
Are you afraid of her?
No, ma'am.
If she were to be released from custody today, would you be afraid of her?
No, ma'am.
And you stated that you do want to have contact with her.
Yes, ma'am.
And you stated that you believe she was off of her prescription medications.
Yes, ma'am.
Do you believe any other drugs or alcohol had anything to do with this incident?
Yes, ma'am, I do.
Okay. And are you willing to call 911 if anything like this ever occurred again?
Can you repeat that?
Are you willing to call 911 if anything like this ever occurred again in the future?
Yes, ma'am, I would.
That's all I have, Your Honor.
Okay. All right, then. She wouldn't qualify for mental health pretrial release anyway because of the nature of the charge, I think, unless that's
You can have
changed.
her screened for it, Your Honor, but I'm pretty sure due to the charges, she won't qualify.
Okay, so, well, let's skip that because it might hold her up anyway. And you'd be the one to bond her out, or?
Yes, ma'am.
Okay. All right, so, this charge of battery with a deadly weapon being a hairbrush is probably, going to be looked at as more of a misdemeanor later anyway. And the witness tampering is, you're telling us she's just off her meds. So does the state have a specific concern other than, what? I'm tempted to look at this as more of a misdemeanor bond.
Your Honor, I would ask that you set bond as it was charged, as there is PC for the charges that have been filed. At a later date, the state may file an information with lesser charges, but at this point, there is PC for what is charged. So I'd ask that you set a bond as the charge is currently set.
Your Honor, I would argue that based on the facts and the testimony here today, that there are mental health issues and the alleged, my client is possibly off of her medication, and again, that it was a brush handle. I ask that you take all of that into consideration in the testimony here, Your Honor, and lower the bond amount. It does appear that this may be a mental health issue.
Okay, and I would note that she allegedly had a threat to kill, but that he's here to tell us that he's going to be the one bonding her out and taking her to Lakeside. So one of the reasons I would lower the bond would be on his behalf, not because of, not taking the charges seriously, but he's known her for 10 years and he has a better vantage point than I do. So I'll go ahead and find probable cause for the charges, and respectfully, even though I'm noting the state's reasonable request, in deference to the witness, I'll set the bond at $500 on the alleged aggravated battery, and $100 on the alleged tampering with a witness. The state's going to ask for no non-prescription drugs or alcohol, and we'll also require no hostile contact with the alleged victim because that's his request, and he seems to know what he's talking about.
Your Honor, they would also ask for no weapons.
Yeah, no guns or weapons. If she has any of those, they normally would be given to the citing law enforcement authority within 24 hours. Yes, sir, did you have another question?
Yeah, at the time, see, I know her sister as well, so I just want to make this known. Her sister is the only one authoritative who could have a vapor active. And that's what would have happened normally. But her sister was in Deltona, couldn't come at the time when all this happened. So I called the police. And that's the whole thing. Like I said, I know it's her medication, she's off of medication. And like I said, I would be the one personally. If she got hostile or got outright, I would call the police.
Okay.
But other than that, I know it's her she's off of medications because she's a whole different person.
Do you want me to order her to be on her meds?
Yes, ma'am.
Oh, okay. Let's, can we add that to the orders?
Yes, Your Honor.
To stay on any mental health prescriptions which have been prescribed.
Yes, ma'am.
All right.
Yes,
Do you
ma'am.
need any other help with that? I mean,
Other than that, I know you said somebody you may have programs or whatever.
well, yeah, now I would have had her screened for the program, but because it's initially charged as an aggravated battery with a deadly weapon, that being a hairbrush, the jail staff will probably not be able to extend that program to her at this time.
Well,
However, when she talks to her public defender, if, could be a way, especially if it gets filed down as a misdemeanor, maybe she would qualify. I'm not sure what the criteria are, sir, because I'm a substitute judge and I haven't, been extremely familiar with the regulations that now apply. So yeah, there is a program, but let her talk, you all talk to her public defender to see if it could be added later. I don't think, if I were to add it right now, it would just hold you up from bonding her out.
Yeah, I just was asking in terms of something like AAA, like something on the outside where she can attend group sessions with other people that's in the same status as her,
Yeah,
like maybe once or twice a week.
yeah.
It would be
I
on
spent
record.
my whole career wanting more of those programs available. If you think she has a drug problem also, maybe a drug court referral would be helpful, if that's what you're talking about.
See, I think when she gets over excited, instead of taking her meds, she resorts to the drugs. which is
Okay,
not-
get her started with Lakeside and talk to the public defender. I'm concerned about referring her to anything here, but, if there's a drug court program or something that could help, I think the public defenders could help refer her to that,
Okay,
okay?
yes, ma'am.
But if I order something now, it might hold her up longer.
Yes, ma'am.
The screening process.
Yes, ma'am.
Okay, good luck.
Thank you, ma'am.
You're welcome.
Thank you.
Yeah, we'll appoint the public defender on that. Okay.
Did Mr. Prince
He
bond?
wanted me to tell her
Miss Prince?
not to have any
Prince?
non-prescribed medication.
Was there a reset from yesterday?
Okay. All right. Did somebody say something?
Yeah. You don't have them? It was a reset from Sunday?
Okay. Is this Mr. Sean Wolford?
That's good.
All right, sir, thank you. We have case number 2021-MO578A, littering charge. And, let's see how this happened. And you got reset. I think you weren't feeling well maybe the other day. Is this applicable today, or,
Guilty.
okay?
Which
Let
is
the
the
public,
littering-
let the
the
public
littering of
defender
the
talk to
city.
you for just a second, okay?
Yes, Your Honor. As this is a municipal ordinance case, I've been authorized on the city's behalf to offer an offer.
Okay. Let her talk to him for a second. Thank you.
Your Honor, he would like to accept the state's offer but withhold credit time served and enter plea of no contest.
Okay, forgive me. I think I heard, as an old lady,
Oh, yes, sir.
withhold time served and what?
He wants to enter a plea of no contest, Your Honor.
Okay, okay. Between that and the printer. Okay, sir. You had a chance to talk to the public defender, but she didn't ask to get appointed, so you don't have to pay an extra $50 or whatever that is. Did you have a chance to read a plea form at some point?
I have one right here if he wants to. I went over them, but if he wants to read over, it's right here, Your
Oh,
Honor.
you mean you went over it in the hall, but he might have not had it in his hand?
Right, I don't know if he had one in his, but I have one right here in front of him.
You've seen that before? Oh, okay. All right, if you're satisfied that you've seen it before and you want to accept everything on the form, then go ahead and sign it. Sir, I'm going to ask you a couple questions. We probably need to get you sworn in. Did everybody get sworn in before in the hall or something? Okay, would you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Sure, yes, ma'am.
Okay, you can put your hand down. Now, sir, are you feeling okay now? Because evidently you were not feeling well enough to come to court yesterday.
That was an assumption.
Okay, it was an assumption. But you're all,
Wrong assumption.
sir?
It was a wrong assumption.
Wrong assumption.
Maybe I was a little bit tired, that's true.
Tired, okay. But you're feeling fine and
I feel fine now.
you're clear today.
I'm perfectly fine, yes, ma'am.
Okay. Now, it is a littering charge. It's a small charge, but it is a crime, so you understand you'd be getting that on your record. You understand that?
Okay.
Even though I think they're
Is
calling
it
it.
illegal to disperse a cigarette?
Well, yeah.
It is, but people do
It's
it?
technically a littering charge, yeah.
Okay, I accept that.
Okay. So you won't have a trial, you won't have a defense, nobody will, well, he just handed me a public defender form, but I'm thinking you want to dispense with that to save him the $50?
Yes, Your Honor.
So, that's a plea form, I'm sorry. I'm so old without my readers, it's ridiculous. Okay, so, sir, then you won't have a trial or defense, nobody will, hear any defenses you might have, and you'll end up with some court costs to pay. Any questions about your rights?
No, ma'am.
Okay, and you're doing this of your own free will?
Yes, ma'am.
Okay, it appears that you are actually alert, intelligent, that you understand everything that's going on right now. It's in your best interest probably to enter a plea and get it over with a time served plea. So we'll accept your plea of no contest, find a factual basis to accept the plea, withhold adjudication, I think was the recommendation of the
Yes, Your Honor.
council. Okay, sentence you the time you've already served, which I don't know if it's 2 or 3 days, but
3
whatever it
days.
is.
3.
3, thank you. Okay, I think basically we imposed the court costs, but are we doing like collections court, or I just give them like 90 days to pay?
Your Honor, you can give him up to a year.
Oh, up to a year, okay, all right. Whatever's normal, I'll roll with it. Okay, so we'll give you up to a year, and, just in regard to these little court cost things, sir, it probably is in your best interest in the long run, because in this state, we tend to suspend people's licenses when they don't pay things, all right? Good luck.
Thank you.
Uh-huh. All right, is this Ms. Fowler? We have case number 2021 CF 569580. All right, ma'am, I don't see any witnesses coming forward. The allegation is aggravated assault with a deadly weapon, and they had enough information to file the charge. First thing we'll do is appoint the public defender. It appears that you do qualify, and we will be providing you with the information on how to get in touch with them.
Yes. Your Honor, she does qualify for pretrial release. I would just ask that she's placed on pretrial release. It seems that, again, this may be a mental health issue, it stated that she has not been taking her meds in the arrest affidavit. So just ask that you take that into consideration, and being that she has no criminal history, that you place her on pretrial release, Your Honor.
Okay. All right. And I don't know if this is one that we should explore mental health pretrial release or not, because I don't know that if that holds her up or if she really gets services.
You can screen her, most likely, due to the charge, they'll just go ahead and submit over that.
Due to the charge, she
won't
won't
hold her.
qualify. Thank you for reminding me of that. Okay, all right then. Any objection to the pretrial release, even though it was an alleged light knife in this particular case? The facts seem to be both people accusing each other.
No, Your Honor, I have no objection to PTR. I was just going to ask for mental health PTR, and if she doesn't qualify, then straight PTR.
Well, yeah.
Sometimes people qualify that, I don't know, but.
Sometimes they qualify and sometimes they don't, but, based on the charge, it might just hold her up.
Okay.
Yes, Your Honor, it's going to hold her. I would just ask for a straight
Okay.
pretrial release.
All right, okay, so, Ms. Fowler, whenever you're charged with what is called a domestic violence case, we're going to have to say no contact with the alleged victim, separate residence for now. You need to get a hold of your public defender, and if you want to have a hearing in regard to contact, because there has to be a judge listening to both sides before any contact is authorized. You can't even contact the person to, tell them you're out or you want to see the child or something. And I think in regard to dealing with the custody of the child, what we do normally is say that you can exchange with a third party, another person like a family member, instead of with the other person. Separate residence, and this one, if you, I don't think you're living together, but if you're not living together, so that's okay.
We were.
No, you don't have to say anything. You were living together?
Yes, we were living together. I have it at a separate place, but when I had my baby 3 months ago, I moved in with him.
Okay.
And I still have that place that I can go back to.
All right,
but
so
I've
you
been
need a
living with him and
police
all my
escort
belongings
to
are-
get some things out of the residence to take back to your other residence.
Yes, and he has my child as well. He does not want to talk to me directly, but he is willing to go through his son or somebody else.
Right, the son or a third party, somebody's mom, somebody's responsible who could handle whatever drama is still happening without you guys having to talk with each other to have visitation and custody exchange.
Yeah.
If you have been prescribed any medicine to help you with your moods so that things can be quieter, I would order that you stay on those medications for now so that we could try to keep things calm while the case is going on.
Yes, ma'am.
And remember, no contact means don't even call him right now until you go through the public defender, talk to the judge, and then he gets specially invited to come and say whether, he wants contact or not.
I am allowed to go through a third party though, correct?
Yeah, well, the third party as far as the custody exchanges,
Okay.
all right?
I can go through his son if maybe I wanted to see my son?
Yeah, to see your son, but you can't go through the son to say, you need to drop charges,
Oh, no. I'm not.
okay? Custody considerations, and any guns, weapons, knives, or anything that you have generally have to be submitted to the law enforcement officers or the law enforcement agency that arrested you within 24 hours. If you're released, you're not allowed to have weapons while you're out on a domestic violence charge. Make sure you contact your public defender so you can know what's going on before you come to court. Good luck. Okay. Chandler Lasley?
Yes, ma'am.
Sir, okay. Case number 2002-1 CF 5702. Okay. Sir, in this case, let's go ahead and appoint the public defender first. And I was a little bit concerned that there might be a case out of New York. Has there been any hold or anything initiated on that?
No hold, Your Honor.
No hold.
Your Honor, for the record, this is 21 CF 5702.
Yeah, thank you. And there's not a witness here in regard to this. The allegation is aggravated battery on a pregnant person. Sir, whenever the person happens to be pregnant, that would turn a regular battery into a felony under Florida law. So in this one, you know, even though it would normally have been a misdemeanor in terms of the allegations of what allegedly happened, it's a felony because of the pregnancy circumstance. So they do have enough information to file it as a felony. And she was not planning to come to court, so we will normally require no contact, at least until you get to court. You can talk to your public defender if you want contact, but the judge needs to have a clear opportunity to talk to the other person before any contact is allowed. And so if you were residing together, there would be, you'd need a separate residence also. And if you need a police escort to get some things out of the residence, then one could be provided, but that's how you would get your things. And in regard to any child custody arrangements, that could be with a third party person like, you know, a relative or somebody, a trusted friend, to exchange the kids at this time. Normally, it's no guns, weapons. If you have any weapons, you would submit those to the custody of the law enforcement agency that arrested you for safekeeping within 24 hours. And he's got a little bit of a record too. I had initially written down 2,500 as a bond based on the background.
Your Honor, that's what I was going to suggest.
Okay. So what?
2,500.
Based on your history, sir, I'd just remind you that any kind of contact, direct or indirect, will result in your bond being revoked. All right, good luck. All right, is this Juan Leon?
Yes.
Okay, thank you, sir. You had a warrant that might have been a surprise. And the new cases are 2002 1 MM 2978W, allegedly resisting an officer without violence, domestic battery, and criminal mischief. Those are going to Division 50. And was there a public defender form on this, or were you thinking about getting a private attorney?
I'm not going to get any attorney in it.
Well, that's a really good way of getting convicted, whether or not you're guilty, you know.
I'll be all right, Your Honor.
You'll be all right?
Yeah.
Okay. Well, any and every time you come to court, they'll offer you the opportunity to be represented because you're entitled to be represented by counsel. And it's generally a much better circumstance for you because, for one thing, lawyers can communicate with the court better than you can.
Yeah, I'll probably end up getting a private attorney.
Private, okay, no problem. In regard to the domestic,
Your Honor, there is an administrative order regarding, even if they don't qualify for a public defender, you still give one at IAs.
oh, okay.
So I just ask that you go ahead and appoint a PD. So
Oh.
we can either hire a public or a
Oh.
private attorney later, and they can
Right.
file a motion and they'll look.
All right, let's explain that to you, sir. I guess the concern is that, it's really in your best interest to have somebody speaking on your behalf so that in case you don't get a lawyer and it really comes down to you needing one, somebody's could start for you faster than if you later decide you want a public defender. So it isn't anything you're stuck with, and as soon as you get a private attorney, they'll get substituted for your public defender, okay? But it's really dangerous to go without counsel. It's a long thing for me to explain to you, but it really, really is. So in regard to the domestic, let's find probable cause. The other person is not here, so we're going to say no contact for now, at least to a judge, until a judge can hear both sides. That means direct or indirect, you can't even call or, tell her to drop a charge through another person. Just don't talk to her until you get orders that tell you that you can. And the resisting, there's probable cause and criminal mischief. So let's go ahead and put a $500 bond on the battery, 100 on the resisting, 100 on the criminal mischief. You see, I don't know if you all were living together. If you were, we'll give you a police escort to get some things out of any jointly possessed premises if you need to. Not supposed to have any guns, knives, or weapons while you're out on bond for domestic. And you would put those in the custody of the law enforcement agency that arrested you within 24 hours of your release if you have any weapons. That one's going to Division 50. Now, there's another one that's a warrant that was signed by a felony judge. It's going to, I think it says Division 13 here? 15, okay. And that is case number 2020CF11998. And the bond was set at $5,000 on a burglary of a dwelling and $500 on a grand theft. Now, I know you might be shocked by that, but the total is $5,500 on that. It was alleged to have occurred on or about July 22nd, 2020. And like I said, a felony judge had signed that warrant. This information is public, it's in the court file. You can actually access it by looking at the clerk's website if you want to see more about what it was about. I know it's shocking to get a bond on something that's a year old, but it was, another judge found probable cause and set those bonds.
Yeah,
Don't say anything about the case because if you accidentally admit part of it, they will have that recording to play back at your trial.
yeah, no, I have no idea what that was about. They just wanted to talk to me, and I never talked to them, the officers, so they put out a warrant. I mean,
Okay,
I guess
well,
I can look it up.
sometimes you talk to them and they don't arrest you now, but then they arrest you later, and so you'll just have to follow up on it now
Yeah.
because they filed it now.
Your Honor, on the 20 CF 11998, state would also request a no return to the burglary and where the grand theft occurred, and no contact with any victims or witnesses. Also,
Okay,
no
all
weapons on that case as well.
right, those are standard orders. We'll go ahead and put that on the paperwork, sir, and if you don't know what it is that we're talking about, where it is, so I would recommend you look it up on the clerk's website and get all the information about where it allegedly was. All right, good luck.
okay, thank you.
All right, Mr. Byron Manning? Thank you. This is, where's the case number? Case number 21CF5718A0. It's going to Division 11. Let's go appoint the public defender on this first. And we will give you information on how to contact them so that you could be prepared for your first court hearing. As you probably know, the allegation is battery, domestic violence, and abuse of an elderly or disabled adult. They had enough information to file those 2 charges, sir. And I think she's not here today.
No, Your Honor.
But so we're going to normally have to require no contact, at least until both of you all can get into court and the court can hear from her version of whether she wants contact or not. So talk to your public defender if you want an early hearing on that. Generally, those can be set up fairly quickly. And I can't remember, but if you have a shared residence, then we'll give you a police escort to get some things out of the residence because we've ordered you to have no contact and live in a separate residence for now. If you don't have any guns, knives, or weapons, you'd put those in the custody of the law enforcement agency that arrested you for safekeeping within 24 hours of your arrest or release. Based on some criminal history, sir, I would set bond, but I was going to set bond at $2,000 on the abuse of elderly and $100 on the battery. And that's, I just get a little more careful with criminal history. Good luck to you, sir. Make sure you come back for all your court dates. $2,000 on the abuse of elderly and $100. Thanks. Is this Mr. Sheffield?
Yes, ma'am.
Thank you very much, sir. We have a case called number 2021-CF5711AO. It's going to Division 12. And we have a witness, so let's appoint the public defender to represent you in case you need some help. Ma'am, would you like to raise your hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Just speak up a little bit because I'm a little, it's hard enough for an old person here without all these masks on.
Okay.
Thanks. And there's a little bit of concern. I think he's got a traffic case in Brevard County that's set to plea June 21st. And I don't know if Brevard is initiating a hold or not, but you're not supposed to be getting a new charge while you're out on bond. It just violates the release conditions of your other charge. So, like, even if we were to conclude this one without doing anything in regard to the Brevard case, what could happen is that just when you're trying to get out on this one, Brevard files a hold on you. Because if they, and that's normal if you're out on bond for something, then now you're going to have to deal with that. And you might actually get a little ride over there to talk to the initial appearance judge before you get released on that. So I'm just letting you know. But I think we're mainly focused on the new one today.
Yeah, I'm just trying to make sure that he gets out this, today, because me and my mom are here to put up his bond. And he has school. He has to graduate and stuff.
Right, okay. So let's have you tell us your name for the record if you didn't already do that.
Tyjazia Leona Nelson.
Okay, ma'am. So the state's probably going to want to ask you some questions, but the bottom line is, do you feel safe enough for him to be released? Do you want contact or not? And the state's going to ask you you want to ask your regular questions?
Yes, Your Honor.
Okay.
Good morning, Miss Nelson. Can you please tell me your relationship to Mr. Sheffield?
Boyfriend.
Approximately how long have you known him?
November will be 2 years.
Okay. Has anything like this ever happened before?
No, first incident.
If anything like this ever happened in the future, would you feel comfortable calling 911?
Yeah.
Do you want to have contact with him?
Yes.
And I know the judge already kind of touched on it. Are you afraid?
No.
If he were to be released from custody, would you be afraid?
No.
Do you believe drugs or alcohol were involved in this incident?
No.
Okay. That's all I have, Your Honor.
Okay.
Your Honor.
Yes, ma'am.
I would just argue as to PC.
On the strangulation?
Yes, Your Honor.
Well, how about, I don't really like to argue with the state about, that, or get another 24 hours to get PC. I understand it's an independent witness who doesn't want to be identified, it's not going to come to court, so there's not going to be any evidence on it. And my normal reaction would be just to set the bond lower because the state's not going to get a witness on that.
Okay, thank you, Your Honor.
Okay. All right, so yeah, there was an independent witness that doesn't want to be identified, said he was choking her. And so that, it's coming in as a felony, battery by strangulation, but if the witness did not provide their name, it's probably going to be filed in misdemeanor court, so we're looking at it that way. But it's still, it's on the record, all this is on your public record. Anybody can look it up, just by looking at the clerk's website. So be careful about this stuff, but I'm going to set it at $500, and no hostile contact means no fighting while you're out on bond.
Okay.
Keep it down. If you get into another fight and police get called again, you'll be in here on no bond probably. If you have any weapons, knives or guns, put those in the custody of the law enforcement department that arrested you within 24 hours of your release. And as I've already told you, Brevard may or may not initiate a hold before you get out of here. Because I think actually the jail staff has to actually probably notify them before they let you out on this. So if you have any complications, then you might want to just start toning it down. Unless you like coming back here. All right? Good luck.
Thank you.
Thank you.
You're welcome. Oh, okay. Thank you. Ms. Sutherland?
Yes.
Right, okay.
Morning, Your Honor.
Good morning. Is there like a trick to this? Never did. All right, ma'am. This is case number 21CF571980, and it's going to Division 22. We're appointing the public defender to represent you, ma'am. So we'll give you paperwork before you get released in regard to how to contact them. The allegation is battery on, I guess, your mother, a person over 65, and if she's not here today, then we're going to need to say no contact with her, directly or indirectly, until you can get into court and the judge, or at least the state attorney's office, has had enough information from her to know that she wants to have contact. And that would involve a separate hearing, so no contact for now. I think you were temporarily living with her, although your things might have been in the car. You can have a police escort if you need to get some things out of her residence.
I can't hear you, I'm sorry.
Okay, so you can have a police escort to get some things out of your mom's house if you need to, if you've got your things in her house.
I have a couple of things at her house. I've been there for a couple of days, but I don't live with my mother.
Right.
I don't understand.
First of all, I'm reading a stack of paperwork that thick.
I know, I understand.
And second of all, I don't know what you have in there. So I'll just say, look, if you need a police escort to get some stuff out of her house, you can have that.
Okay.
But no contact until a judge says otherwise, because we have to have victim permission to give you contact. And no guns or weapons. If you have any of those, you put those in the custody of the police agency that arrested you within 24 hours of your release. You're not allowed to have weapons while you're out on bond for a domestic violence case. In regard to this, I had a relatively low bond, counsel.
Your Honor, arguably this potentially could be filed as a life offense since she barged into the house. So I would ask that you set bond as it is currently charged, not as it may be charged in the future as the ASPC for the charge that is currently filed.
Your Honor, I would just ask that you take into consideration that this was a mother-daughter incident, the fact that my client has no criminal history, and the fact that it seems to be currently unemployed at the time. So I just ask that you take all of that into consideration. And it does say she's currently homeless, so, and lowering the bond amount in this case.
Okay, and then, and the other consideration was just drug use probably is aggravating the situation, so, it, normally the state's gonna ask for no, unprescribed medications, even though that's, hard to enforce, but another, way that you could violate your bond if you're on drugs. But I respect the state's request. I think I know how this is going to go down the line. I'm just going to give it a $500 bond. Tell you, stay away from your mom, stay off of the drugs, and try to make all your court dates.
Thank you, Your Honor.
Okay, the next case is for Mr. Colin Thomas, and it's case number 2002-1CF558880. It's going to Division 19, and I'm not seeing a public defender form on this. Are you getting a private attorney?
Well, I didn't know if I needed a PD or whatever the case may be, and I didn't know.
Okay, the prosecutor reminded me that we're probably going to appoint the public defender anyway, just in case, because, so if they hand you a form, it's probably better that you fill something out.
All right, yeah.
But it's really not safe to go without an attorney, and it's better to just have one. And even in the meantime, if you want to hire a lawyer, that's fine. They'll just substitute out. Okay? But this was I believe this was a warrant, alleging an aggravated assault with a firearm, domestic, that allegedly occurred on May 13th. And it comes in originally at no bond. I think okay. In addition to appointing the public defender, it's a no contact requirement unless the judge will hear from both sides in regard to whether it's safe, whether the person wants contact. I know you have at least one child in common, and any child custody exchanges need to be done with a third party, not directly with the child's mother. I don't think you're living together, so I'm pretty sure we don't need to give you a police escort to get some things. And since the child allegedly saw this incident, I'm not sure how this is going to be filed eventually.
Yeah, the thing.
Don't say anything about the case. Anything you do say could be used against you in a court of law.
Yeah, I understand.
And you just talk to your lawyers about that. But I'm concerned about the allegations that you pulled out a gun and that the child was in a car. That, I'm tempted to tell you not to have contact with a child, but I'm just wondering if there's going to be any dependency action or anything filed in regard to that. If there are, I'll let the lawyers tell me what they think about that. And I was inclined to set bond, but if y'all want to be heard about the fact that it was an alleged gun being pointed at them, let me know whatever you,
But that's not true.
well, okay, we understand that there might be two sides to the story. What we're trying to do is make sure everybody's safe. And when it comes to guns, my anxiety level goes way up.
I understand what you mean.
It just-
Can I just say something?
No, well, you can say it to your lawyer, but you don't want to, you want to cover the microphone. Oh, wow. He's had some arrest history, too. Okay.
Okay. Your Honor, as to bond, he does qualify for pretrial release. So I'd ask that you place him on pretrial release. If you're not inclined to place him on straight pretrial release, I just ask that you lower the bond amount and place him on pretrial release and give him a small monetary bond. If you look, his last conviction was in 2007, and my client is currently employed full-time. He does state that he has an active injunction on the alleged victim to protect him, so it seems to be there's a lot of missing facts to the story, so I ask that you take all of that into consideration when setting the bond amount in this case.
Okay, now, the Florida arrest history, was that in regard to making a false report, or are those other charges, like homicide, was that a separate charge, or was he allegedly making a false report about a homicide? I mean, when I see, like, a gun allegation plus a homicide charge.
Your Honor, that case wasn't in Orange County, so 1 second, please.
Well, I mean, pretrial release compiled some information here on the Florida arrest history, and it has a bunch of things separated by commas, including making a false report, resisting without violence, grand theft motor vehicle, homicide, willful killing.
Yes, yeah, that's
So-
an actual charge.
It's what?
It was an actual charge. He was arrested on that charge.
He was arrested for homicide? And nothing came of it evidently because it supposedly qualifies for pretrial release?
Your Honor, state would object to PTR. I know he otherwise qualifies. That doesn't mean that he's entitled to be placed on PTR, given that there was an allegation of a firearm in this case, given his arrest history, and given that there was a child present. It was a violent in nature offense. Therefore, state would object to PTR. If you are inclined to put him on PTR, I would just ask for a monetary bond in conjunction with PTR. And in regards to conditions, I'd ask for a no return to the victim's residence, no contact with victims or witnesses. That would include the child, as the child was a witness, and to comply with any DCF investigations, if any are undertaken.
Okay, all right. I understand now. She's reminded me that the child is now a witness. So I think it would be safer, Mr. Thomas. I've already articulated the reasons why this makes me pause. And, you know, I understand your opinion is completely different, but from my perspective, I have to be careful. I'm going to say no contact with the child's mother, no contact with the child for now, unless or until the judge can hear from everybody about the safety in the situation. And in addition, as the state recommended, which is standard and appropriate, if there are any orders out of the Department of Family and Children's Services or juvenile court dependency action in regard to the child's welfare, that you would comply with those orders as well. You surrender that gun, any guns or weapons that you may have, within 24 hours of your release to the arresting law enforcement agency. Looks like Orange County Sheriff, I think. And contact, it can't, be indirect or anything. Now, it must be a numerical issue in regard to this PTR allegedly being available to you, but, on these gun charges, I'm normally at 5,000.
Your Honor, I believe that's reasonable given his history and the nature of the charge.
I don't know how to explain it to you, but I've had, sworn to practice in 1980. I had a lot of years of experience, hundreds of thousands of cases, and to me, it's a $5,000 bond on that. Good luck. Don't make me sorry I let you out. Daniel Tull, sir? Thank you. Well, no, if I didn't articulate it well, no return to the residence of the victim. I don't think they were living, no, they weren't living together. Okay, so Mr. Tull, there's a witness here. Let me just get to it. I have to state the case number for the court reporter, which is 2021 CF 5690AO. And its division, is this an 11 or a 16? 11, Division 11. Will appoint the public defender to represent you, sir, so that you could be represented for this hearing and every other kind of thing. Oh, does not qualify? Weekly? But does the admin order say we appoint them anyway just in case?
Your Honor, my understanding of the admin order is they're appointed at IA, just in case, definitely for like no bond cases, just so the PD can, this isn't a no bond case. But particularly for those, just so there's someone actively working until they are able to obtain a private attorney if they don't otherwise qualify.
This is one of those where it's not wealthy either. Is that your weekly income that you put down?
As far as, I don't know.
On the public defender form?
That's monthly.
Monthly?
Yeah.
Oh, if that's monthly, then you're going to qualify. Let me go ahead and, if it doesn't work out because of your income, they'll figure it out. All right. We'll appoint the public defender for now. So the witness, would you raise your right hand to be sworn in to tell the truth? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. And could you state your full name for the record?
Jose Rodriguez.
Thank you, sir. Now, the state's probably going to ask you the same question, so I'll probably just let them do it because they want to do it anyway. But the bottom line is whether or not you want contact, whether you're afraid, what circumstances do you need, if any, to help you make it safe? It looks like your eyes still a little black still.
Yeah, yes it is.
Okay.
Would I be able to drop the charges?
Not here. You can note it for the record, but they're not going to tell you that it's dismissed today.
May I inquire, Your Honor?
Yes, ma'am.
Good morning, sir. Can you please put your name on the record again?
Jose Rodriguez.
Thank you. And what is your relationship to Mr. Tull?
He's my girlfriend's brother.
Okay. Approximately how long have you known him?
More than 15 years.
Okay. And has anything like this ever happened before?
No, never.
Okay. Are you afraid of him?
No.
Do you want to have contact with him?
Yes.
Do you believe drugs or alcohol were involved in this incident?
Yes.
And are you willing to call 911 if anything like this ever occurred in the future?
Yes.
That's all I have, Your Honor.
Well, I chuckle a little bit because I think this is the one where they were trying to keep him from driving, the alleged victim.
Yes, Your Honor.
Because they thought he was too intoxicated. And so that, I don't know if that's what he was referring to when you asked if drugs or alcohol were involved. So, I don't know. I don't see anything, I don't remember anything about the police officer saying that Mr. Tull was intoxicated, but, okay. So, but you want no hostile contact, right?
Right, well, it won't be no hostility.
Okay,
Your Honor, he does qualify for pretrial release. I would just ask for pretrial release. It looks like he has no criminal history.
okay,
Either.
Your Honor, the state doesn't object to PTR,
Right.
given the victim's testimony here today.
right, okay. Okay, folks, this will probably resolve okay as time goes on. But pretrial release, you'll, hopefully that doesn't hold you up. And it's an alleged, why is it a felony battery?
The injury sustained, Your Honor.
Oh, all right, okay, so we will, on an academic sort of basis, call it a probable cause for the felony battery, and it'll be pretrial release, or if that holds him up for any reason, it's not gonna hold him up,
No,
okay.
Your Honor, it won't.
Okay, just pretrial release, no fighting, no hostile contact while you're out. If you have any guns, knives, or weapons, put those in the custody of the arresting agency within 24 hours of your release. Make sure you come to all your court dates. I don't know if the public defender application is going to stick or not, but, just trust the process and make sure you come back to court.
Would I be able to get him out today?
Yeah. I'm not sure how fast they are, but yeah.
It's pretrial release. He doesn't have to pay a monetary bond to get out.
Okay. Thank
All
you.
right, good luck. Okay. We're at the Okay. Thank you. That is 2002-1MM 3329, and we didn't have a public defender form on that. Do you want to just call back tomorrow?
No, Your Honor, you can appoint us and I'll waive the appearance.
Okay. Let's go ahead and appoint the public defender. Find probable cause for the misdemeanor battery. If there's no witness here, say no contact until a judge can hear from both sides. On probation. There's some priors, but I guess it'd be appropriate as a misdemeanor to set bond at the $500. And I don't think that this was a common residence.
Your Honor, I'd still ask for a separate residence and a one-time return with law enforcement.
Okay, we can order that, and no guns, knives, weapons, put those in the custody of the arresting police agency within 24 hours of release.
Also, no alcohol, Your Honor. There was an allegation.
Okay, no alcohol. Thank you. Is this Mr. Espinoza? Thank you, sir. All right, this one is case number 2002-1MM3329AO. Did you was that your weekly salary, sir, or was?
That's I usually get paid by the contract. I usually don't get paid weekly, but I usually get paid every week or two from that.
Okay, did you estimate how much you?
Yeah, that's a round of an estimate how I would usually make a week.
Okay,
But if it was considered from the contract, I would make probably way more than that at the end of the contract.
okay. Well, even in regard to your estimate, they're saying that you don't qualify. I mean, it looks like you're not wealthy, but evidently you don't immediately qualify for the public defender. So,
Well, how much does it got to be to be to qualify for the public defender?
you got to actually be kind of in very dire straits financially.
Yeah, I mean, I know I make more than that, but I was just giving a good round estimate.
Yeah.
Yeah.
So, well, I think what's going to happen is I'll decline it for now, but then whenever you come to court, they'll maybe ask you, you can ask again if you think you need the public defender. You might want to check in regard to a private attorney before you get back to court. Trying to figure out where I put. And okay. In general, we don't have a witness here today, so we're going to order no contact with the alleged victim. Separate residence, if you need a police escort to get some things out of the residence, then that will be provided. If you have any guns, knives, or weapons, make sure you put those in the custody of the police agency that arrested you. State's going to ask for no alcohol because there were allegations that alcohol was involved. There is enough information in the file to find probable cause for the battery charge.
Your Honor, state would ask for a higher bond than the standard 500 for a misdemeanor battery. He does have a fairly lengthy battery DV history.
Yeah, my last.
2013, 2015, 2015, 2013, 2015, 2013, 2016, 2015, and 2019.
Your Honor,
Just speak up a little bit.
Your Honor, he does qualify for pretrial release, and it seems that his risk assessment came back below average. My client is currently employed full-time. He resides in Ocoee, Florida. It shows the last conviction was in 2019 for battery, so I just ask that you take all of that into consideration. If you are inclined to set a high bond, that you place him on pretrial release and lower the bond amount.
Oh, I see. What you're asking for is that there can be a bond plus pretrial release?
If I would ask for my first request a straight pretrial release. However, if you're not inclined to do that, Your Honor, I would just ask that you lower the bond amount and add pretrial release in addition to the bond that you would set.
State would ask that you don't place him on pretrial release. As I previously mentioned, he has a very significant DV history.
Yeah, I understand that part. He really does. And although, sometimes the numbers add up to pretrial release, sometimes it doesn't jive with the record in my experience. So I know what you're saying in that regard. But what I was just clarifying is that, or trying to remember that if there's a bond plus pretrial release, there's a little bit more supervision. Which I think might be appropriate. Okay. All right. Sir, let's go with a $500 bond plus pretrial release. Pretrial release will help just manage the situation, and require that you don't have alcohol, things like that. If you get rearrested, they'll know right away. I understand it was a wedding, and that's where the things got out of. Don't say anything about your case because everything's being recorded. You just want to talk to the lawyers. But it's difficult for me to look past your history and just do pretrial release. It just doesn't seem logical. All right. Make sure you come back to all your court dates, sir. And I'm sorry I couldn't appoint the public defender right out, but tell the judge later if you tried to get a lawyer and you couldn't afford one. Okay, I think we're up to Mr. Miguel Flores Gomez.
Good morning, Your Honor.
Good morning, sir. And the case number is 2021-MM-296-AW. And you might not qualify for the public defender either. You're not like a wealthy person, but so you probably want to be represented. If you can't get a lawyer, tell the judge when you come back and see what kind of considerations can be made. You do need to be concerned about criminal history. It appears that they have enough information to file the charge of battery, sir. And since the witness is not here, we're going to require no contact until a judge can hear from both parties and determine that it's safe. It appears you don't live together, but the state probably wants me to add that if you did have some things at the residence and you need to get them out of the residence, you can have a police escort to do that. You're not allowed to have any guns, knives, or weapons while you're out on bond for domestic battery, so you would surrender those to the law enforcement agency that arrested you within 24 hours of your release. This is another one where, sir, I don't know if they told you that you qualify for pretrial release, but when you have a history like this, I would be more inclined to set a bond instead of just do straight pretrial release. It's just a long history I've had, and I think it's appropriate. So unless you want to say something, I'll just go ahead with that.
No, Your Honor, state would ask
bond,
for.
I think is appropriate on this.
Since he otherwise qualifies for PTR and we don't have victim input, state would ask for PTR with a bond.
Okay, PTR and a bond. Make sure you come by all your court dates, sir.
Your Honor, what is the bond amount on that?
500.
And just to be clear, that was a separate residence with a one-time return?
Yeah, okay.
Was it just 500, Your Honor, or 500 and PTR?
I said the 500 and the PTR for now. Thanks. All right, thank you. Mr. Harrison? Vince? Okay. All right. Let's see what we have here. We have two different cases that start out with different judges, because that is just how they start out here. Because there's a separate court for the domestic battery case, that one gets assigned to Division 50, and that's case number 221MM3335AO. But the other one, we'll appoint the public defender. You can ask them questions too.
What?
Well, they also filed a possession of drug paraphernalia.
We found it up on the car.
Sir, you might want to remain silent because anything you do say could be used against you. All right, so, but let's do, so one of the things I want you to know is you might end up with two different court dates when you first get out, and I know that's confusing. Just be careful about it. So originally, the domestic battery charge and criminal mischief, which was the subject of a warrant, and it was signed by a judge. And the allegation was that it had occurred on May 14th. So probable cause was already found. And there's no witness here. It was alleged to have been involved with Ms. Harris, and that you supposedly had broken a window. Oh, and then there was a face slap or something with the hand. Then the other one was supposedly a crack pipe, and maybe you trying to get under a car. So they had probable cause for the new charges. We'll file a requirement on the domestic battery that you not have any contact with Ms. Harris until you see a judge, and the judge knows that it's okay for you to have contact. If you have any guns, knives, or weapons, put those in the custody of the arresting agency within 24 hours of your release. The state's going to request separate residences, even though I don't think you live there. Police escort if you need to get some things out of the residence. And
Your Honor, for the record, this is 21 MM 3335, correct?
right, that one's going to Division 50. Seems like the main problem he's got is drugs, not violence. So, but he doesn't qualify for pretrial release. Let's say that the dating battery is at 500, the criminal mischief is at 100. And the I want to put subsidiary bonds on the two misdemeanors that were related to the arrest of 150 and 150. So I've given you bonds that hopefully you can deal with, appointed the public defender. Stay away from the young lady, and just talk to the public defender about your defenses. All right, Brianna Leaks. Okay. Let's see here. This is case number 2021 MM3318A0, and the allegation is domestic battery. And is there separate criminal mischief on this?
No, Your Honor, she has an out on bond.
Oh, okay, so she was out on bond on the battery, and the new one is a criminal mischief. Wait a minute.
Your Honor.
Out on bond on both?
She's out on bond on a battery and a criminal mischief case, and she's currently before the court on a battery DV case.
Okay, so the criminal mischief that she was out on bond for was 2020 MM6444AO. The battery that she was out on bond for was 2002 1 MM479BO.
Your Honor, in regards to both of those cases, it's a condition of bond and pretrial release, not to pick up any new charges. As she picked up a new battery while she's out on bond on a battery, State would ask that you revoke both and set bond at nothing.
Your Honor, and I would just argue that my client doesn't have any failures to appear here. You can revoke, if you're inclined to revoke the bond, that you revoke and set a higher bond. My client's arguing that the case was dropped. I'm not sure how.
The card or the criminal mischief?
The battery.
Well, you know, Ms. Leaks, you can look up the case by going into the Orange County Clerk of Court website
Yes,
to
ma'am,
check. Just, I don't want to argue with you about it. I'm just telling you, go ahead and look it up online and see if you are sure that it got dropped or not. Evidently,
That case is open and still pending.
sometimes we think it got dropped and it did not.
No, I had a private attorney, Ali Blaker, and he dropped the case because I had bonded out and I went to court.
Ma'am, you have probably misunderstood. You need to look it up. You need to talk to the lawyer. I'm not going to change it right now. I'm not going to change that situation. You need to look it up and talk to your lawyer.
Your Honor, she was never arrested on these cases. There were summons that were issued,
Oh,
but it shows that they were returned unserved due to her not living at the address that was,
well, thank you for clarifying that. That would explain why she thought they were dropped.
Right. I have the criminal mischief it was a return to state case and not served. I have the battery, she failed to appear at arraignment.
Maybe I should look that up, but I didn't get myself plugged into Odyssey earlier today. Maybe just check it again.
She's saying that
the
she
same
went,
for
that
the
the
battery
victim
one,
is the
too.
one.
Wait, I can only hear one thing at a time.
Sorry.
Who wants to go first?
I just see on the court minutes for the battery case, it seems like it was the same thing. It's saying it was returned to state to perfect service. So I'm guessing.
I'm having an investigator serve her today on both.
So she hasn't been served on.
All right, okay, so, all right. Well, I'm not going to look at it as a failure to appear then. So, Ms. Leaks, this is probably very confusing. So let me just try to explain a general kind of thing, because I didn't log into that court database, so I can't check. However, as I've told you twice, everything's available online. You don't have to go to the clerk's office to look up your file. You can look it up by going to the Orange County Clerk of Court, and you can see everything in there, okay? So sometimes what'll happen is somebody will call the police, you don't get originally arrested, but the state might file it later. And as a matter of fact, I've seen things sit in their office for up to a year before somebody gets around to filing it for whatever reason that I can't explain because I don't run that office, okay? So it gets filed later or something. And if they don't have a present address, then they call it up to court once or twice, and you're not there because they don't have your address. And so they didn't notify you because that got sent to the wrong address. And that's what happened. Now, the older it gets, the less that you're going to have to worry about it, but the truth is it's still sitting there. So you're going to have to go to court and deal with it. I think not really having access to those old ones, what's going to happen is they're going to go ahead and serve you with a summons before you get out. But I won't take any action on those.
Yes, Your Honor. In regards to setting bond in her current DV battery case, state would ask that you don't set the normal $500 for a battery misdemeanor. due to her criminal history, that she was out on bond or had committed the offense of a battery. When she picked up this new battery, even though she hadn't been served on it, it was out. She has another prior battery, DV from 2019. She currently has a 2021 criminal mischief that she hasn't been filed on yet. She has a 2021 misdemeanor battery, the one that was here. She has that 2020 criminal mischief. And then a 20 CF felony battery that was no billed. So there's a pattern of
possible
behavior.
anger management problem.
Yes, Your Honor, there's a pattern of behavior between batteries and criminal mischiefs.
Okay,
So I just ask that you set a higher bond than the standard 500 on this misdemeanor.
all right. I didn't get down this far into stacks. Let me just look at it. Okay. Well, there's enough for the new battery charge, even though I understand there might be two different points of view.
Your Honor, I just asked that when setting bond, you take into account that her last conviction was in 2017. She has 0 failures to appear for court.
Okay.
I just asked that you take all of that into consideration when setting the bond amount. And she hasn't been served on the out-on.
Okay, all right. Look, I understand the state's recommendation to go with a higher bond. I'm just going to go with the 500, which is standard, because it's already, you're going to probably have to deal with those other old cases too. So you've got a lot to deal with, and it doesn't appear that you got well, you do have a bit of a arrest history, Ms. Leaks. So, you know, there does come a point where we start to pause and look at it carefully to make sure things are safe. Because the judge can see everything you've ever been arrested for, whether or not you were convicted. So, you know, you might be at a point in your life where you want to consider the whole anger management situation. I don't know if there's anything else going on that you need to deal with, like counseling or whatever, but that's just my advice. We're appointing the public defender. Now, these other cases that were sitting out there that you didn't know about, be careful about what your court dates are. So the other thing that's going to happen is that when you first get out of here, you might have at least 2 court dates, if not 3. So whatever lawyer you get, did we appoint the public defender? So evidently you qualify for the public defender now, even though you had a private attorney. So we'll appoint the public defender on these, and if you get the private attorney again, they'll substitute in. But in the meantime, talk to the public defender about trying to get them all put in one courtroom so you don't have 3 different court dates.
Your Honor, were any conditions set?
I think I'm getting asked the same question in 2 different directions. It's and the clerk's asking me for conditions, and you're
Yes, Your
gonna
Honor,
ask
I don't believe any conditions were
Forgot the
set.
conditions. Okay, the conditions, because I was concerned about you hyperventilating with all these cases going on. It's no contact with the guy, Anthony, I guess his name is. And as far as I can tell, it's your residence, and he was moving out.
Your Honor, I'd still ask that you order separate residences with a one-time return with law enforcement, just so they cannot live in the same residence.
Well, I'm not trying to determine whose house it is. I'm going to order separate residences, and I'm assuming that he's had time to get his stuff out by now.
Your Honor, I just don't know if she has anything possibly at his house. That's why I was asking for the one-time return with law enforcement.
I think the public defender's asking her. I don't think so. I think he was living with her, but. Does she need a return order?
Your Honor, it's her sister's house. He does not reside there.
Okay, so we
So I
don't
would just
need it.
ask for maintain a separate residence.
Just maintain separate residence, no contact unless the judge hears from both sides that it's okay. And good luck with the various charges.
Your Honor, are you going to order no weapons?
No weapons. I thought I said, but if I didn't say, if you have any weapons, put those in the custody of the arresting agency within 24 hours of your release. Thank you. Okay, is this Skylyn McElroy?
Yes, ma'am.
Okay, thank you. We have case number 2021MM3325AO. And also 2020 CF10241AO. I guess those are first appearance detainers. Let's see what we got. And we've got a battery domestic dating violence of 2021MM3325AO. And we'll appoint the public defender on the battery charge. Let me go ahead and look at that first. It's going to Division 50, but since you have these other cases going on, it gets confusing. You might have separate court dates on the different charges, so be careful about that. In regard to the batteries, generally,
Your Honor, I believe there's a victim.
There's a witness.
oh, there's a witness here. Okay, thank you. Would you raise your right hand to be sworn in? Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. Could you tell us your full name for the record?
Dwayne Gordon.
Okay, thank you. Sir, I know the state's going to want to ask you the same questions anyway, but it's basically about safety, whether or not you want contact, and do you need any additional requirements? State, did you want to go through those?
Yes, Your Honor.
Okay.
Good morning, sir. Can you please state your relationship to Miss McElroy?
Friend,
Okay. Approximately how long have you known her?
a year.
Has anything like this ever happened before? Was that a no?
No.
Could you speak up for me, because I'm trying to read it at
No.
the same, thanks, okay.
If anything like this ever happened in the future, would you feel comfortable calling 911?
Yes.
Do you believe drugs or alcohol had played any part in this incident?
No.
Do you want to have contact with Miss McElroy?
Yes.
And are you afraid of Miss McElroy?
No.
That's all I have, Your Honor.
Okay. Anything else you want to say?
Would she be able to be released today?
Well, it's a misdemeanor, so, but the other problem is, these other charges that I've got to look at, the driving while license suspended, and
Your Honor, that 2020 CF 10241 case that she's out on bond for, that case, the charges are attempted manslaughter, fleeing and attempting to elude, and possession of a controlled substance. Due to the nature of the offenses and that they're violent in nature, and she picked up another violent in nature offense, state would ask that you revoke and set it at no bond, so she can get in front of the trial division to have a bond hearing.
she's got a public defender on those.
Your Honor, I would just ask that if you are inclined to revoke, that you revoke and set a higher bond in that case.
Sir, you said you wanted no hostile contact?
Yeah.
Okay. All right, well, it gets a little complicated. When you're out on charges of this type, and I didn't study the old charges, just that the allegations themselves are concerning. In regard to the battery, will require no hostile contact. Did you need anything else, like no drugs or alcohol?
No, everything. She doesn't do no drugs or alcohol.
Your Honor, respectfully, her history says differently.
Oh. No guns or weapons, put those in the custody of the arresting agency within 24 hours of any release. Your record's starting to catch up with you. I'll go along with the state's request of no drugs or alcohol while released on the battery. And in regard to the driving while license suspended, I guess those are, it might have a, is that now, is that, that one's 221 MM 3325 AO. I'll leave the bond at 100 on that. The felony, however, the 2020 CF 10241 AO.
Your Honor, you said the bond is 100 on the battery?
Well, no.
On the Dwellis?
That's on the Dwellis.
You're going to revoke and set it at 100?
At 100 on the Dwellis. Oh, I said the wrong case number?
Yes, Your Honor.
I say the Dwellis, I'm sorry. The Dwellis is 2020 CT 5219 A0. On that felony,
Your Honor, I don't believe there are any reasonable bond conditions that you can set that would.
well, here's the problem. Here's the problem. The circuit judges are probably going to prefer that you go back in front of them for them to evaluate the situation. And so I'm going to no bond you on that, tell you to contact your public defender and get yourself a hearing, because it's a serious charge. And that felony judge, I've let people out before and got in trouble with the felony judge for letting somebody out. So I'm going to say you need to go in front of that judge.
On the battery,
Battery's
Your Honor?
500. He's not worried about that battery, I don't think. But
Are you, to my understanding, you're taking no action on the Dwellis?
correct.
Okay.
I thought you revoked and set it at 100.
But I revoked on the felony, fleeing, attempting to elude, attempted manslaughter, because that evidently was pretty serious. But the Dwellis is, I think it's a misdemeanor court for one thing, and so we don't need to hang her up on multiple charges, just the one. She goes back to the felony judge and they give her a bond, that's fine.
I'm sorry, what was the battery bond amount?
Battery was 500.
Thank you.
Took no action on the Dwellis because it's in a separate court and I don't want to make it extremely complicated. But she can go back and talk to that felony judge before she gets out.
Thank you.
Ma'am, you need to calm down.
Oh no.
Look. Okay. Is this Mr. Mendez?
Good afternoon.
Good afternoon. Probably seems like that in here. You can't tell what time it is in here. Okay. We have case number 2021 MM 189AA. And the allegation is battery. It's going to Division 50. So your income, although you're not wealthy, at the moment, you don't qualify for a public defender. If you can't get a lawyer, you should probably have a lawyer. And if you come back to your next court date and you've been unable to, talk to the judge again about qualifying for the public defender, but right now you don't qualify. If you try and you can't get a lawyer, a private lawyer, let the judge know. Because it'll be important that you have the opportunity to be represented. Okay. Now, in regard to the batteries, since there's no witness here to tell us that it's okay to have contact, our first order is no contact until you get in front of a judge and the judge hears from both sides and makes a determination that it's safe. And there would be separate residences required. If you do have the same residence, then we'll give you a police escort to get some things out of the residence. Now, you have a child in common, so any custody exchanges would be done through a third party, such as one of your mothers or a sibling or something. Did I already tell him to submit any guns or knives into the custody of the same agency that arrested him? Okay, so we'll order that. You know, this one, it says he qualifies for PTR. He's got a little bit of a history. I'm not hearing the state say anything substantially. So, you know, sir, we're doing more pretrial release these days than what I was used to. I'm a retired judge, so, you know, I would tell you, I mean, I'll go along with that because there's all this concern about cash bail and all that nowadays. But I just want you to know that you're getting some things on your record. It's the kind of thing that a judge would look at. It's not like intuitively obvious that I would just let you back out. So just be aware of that, but I'll go ahead and authorize pretrial release because evidently that's what your score is. Don't have any contact, direct or indirect. Don't, you know, try to tell her to drop charges or whatever. That's a violation of bond.
Your Honor, there's a note that he plans to return back to California.
There was a note that he plans to return to California?
Yes, Your Honor.
Oh, okay. Well, you know, that would solve Florida's problem. But you would never be able to come back here because there'd be a pretty big fat warrant for your arrest, which might also solve Florida's problem.
Where the narrative is?
For your information.
Can I speak?
Well, I would recommend you not say anything about the facts of the case because it could be played back at a trial.
So on record, Your Honor, you're going to allow him to go to California being on pretrial release?
Oh, is that the question that he wants to know if he can go to California?
Your Honor, he told pretrial services when he was interviewed that he planned to return to Burbank, California. That means PTR is going to have to supervise him in California. So it just causes a little bit more difficult. So you have to order that he's allowed to return to California if he's on
Is that,
PTR.
okay, so that's something that you guys are okay with, that you could
Yes.
supervise him by phone?
Yes, but it just has to be on the court order that you're going to allow him to go to California.
Oh,
being
okay.
on pretrial.
Oh, I thought that the state was telling me he's planning to, like, flee the jurisdiction. Okay, sure.
Thank you, Your Honor.
We'll let him to go to California if PTR's okay to supervise. You know, so they'll call you, they'll try to keep track, and you'll still be required to come back to court dates. All right.
Thank you.
You're welcome. Okay, is this Miss Osorio? Thank you, ma'am.
Yes, Your Honor.
Thank you. This is case number 2021-161-938. Allegedly a violation of domestic violence injunction. The paperwork indicates that you might not qualify for the public defender at this time. If you try to get a private attorney and you can't, advise the judge at your first appearances in court because it's important that you're represented. And so that needs to be dealt with. Um, Okay. Looks like out-of-state history. And forgive me, but I need to look at the report for a minute. Airport. Oh, okay. Well, okay. Did you want to say anything? I can deal with it, since he's trying to get the injunction dropped.
Your Honor, respectfully, we don't have his testimony here today that that's what he wanted to do, and the injunction is still in effect.
Well, obviously, no contact.
Yes,
but
Your Honor.
Just in regard to the size of the bond.
Yes, Your Honor. On these kind of cases, generally, Judge Bain and Judge Gibson said they're rather high due to the nature of the offense and that there is an injunction in place. And we don't have victim input here today regarding his intent. I know the officer wrote in the affidavit that the victim explained that that was his intent.
Yeah.
However, we cannot ascertain if he said that because he was in front of her or anything like that. And there is PC for the charge. Therefore, I'd ask that you set a bond that is in keeping with what the charge is.
Your Honor, I would just argue that if the officer wrote that in his police report, that you take that into consideration when setting the bond amount. Even in the arrest affidavit, they were under the impression that it was already dropped. So I ask that you take all of that into consideration when setting the bond amount. It does not appear that it was intentional.
Your Honor, the injunction itself was a non-expiring injunction, which I'm sure from your years on the bench, you understand what the facts had to lead up to get a non-expiring injunction. And I understand that the victim said that he's been trying to get it removed, however, he hasn't. So I just ask that you take that all into account.
Right. Okay, well, I think I've probably heard enough without us repeating ourselves. Ma'am, I'll just set the bond at 500, and the court orders will say no contact unless the injunctions drop, but generally no contact is required on this order anyway until a judge hears from the other party. So you're probably going to have to get into court to get that no contact order dropped. So if you have any guns, knives, or weapons, put those in the custody of the arresting authority within 24 hours of your release.
Your Honor, I believe she's going back to Rhode Island.
Oh, because they were at the airport?
Yes, Your Honor.
Well, that's a problem. You're going to have a court date here. Now, I'm not adding any requirements such as checking in with pretrial release, but you need to make sure that the court system has your correct address, and, you'll have a case to deal with, and we didn't appoint you the public defender, so you're probably going to try to check in with a lawyer also. You just have to deal with it. You'll have a court date in Florida, and you want to make sure you attend that, because otherwise you'll have a warrant out for failure to appear. All right, just for the record, public defender's still talking.
Just because I understand she doesn't qualify, but given the administrative order, would you mind just appointing us right now until she's able to get back home and get an attorney, being that?
Yeah, no, that's fine.
So that we can stay on, I don't want her to have a failure to appear. At least we'll be able to point her in the right direction.
Okay.
Thank you.
You're welcome. Thanks for asking for that. According to the barcode, the next case number is 2002 1MM 3315 AO. Bless you.
Okay, Your Honor, I'm sorry. Can we scratch the public defender? It appears she did actually, because it's a violation of the injunction. She does have an attorney in Rhode Island, assigned to that case. He already knows the court dates. She has one coming up.
Well, so let me just clarify something.
Okay.
We, you need an attorney here. And I think the first suggestion was practical, just to make sure that you've got somebody to communicate your court dates.
Okay.
And if that Rhode Island attorney, you don't want to pay them to fly down here for your court date. You're probably going to need one here. And so if you want to substitute one for the public defender, by all means, do that. But this is a second case.
Okay.
It's a whole separate case. So we'll stay with the PD for now. Okay, thanks. All right, is this Ms. Saylor? Yes, Your Honor. All right, that was the case number 2002-1MM3315. It's going to Division 50. And also, in this case, initially, you're not qualifying for the public defender, but if you can't get a lawyer by the time you come to your first court date, unless the lawyers want me to point it on everybody, tell the judge if you can't get a lawyer, and they'll explore it a little deeper as far as whether or not you should get a public defender. Do you understand that part?
I think so. When I was listening to the prior case where she had mentioned, I'm sorry, that I could have a public defender in place until I could find an attorney and then they could communicate. Is that what I understand?
Is that what we're doing now? Okay, well, let's.
Pretty much, Your Honor, just to keep judicial efficiency moving.
Right, I
We don't
get
want them
it.
sitting here with no attorney.
Okay, we'll do that. I'm a retired judge, and they're having to update me on what's going on now.
Gotcha.
All right, so the allegation is the domestic battery, and we always, if the person isn't here to testify, we're going to say no contact, separate residence, unless the judge can hear from both of you and make sure that it's safe.
He already flew back to home.
Well, you don't have to say, okay, so like, what, were you on vacation or something?
Yes, Your Honor.
Yes.
All right, okay. Let me read it real quick, because I didn't get this far down in the stack. Oh. Okay, well, they got enough information to file the charge. And you're going back up to, what is it, Virginia?
Maryland.
Maryland, okay. Oh, I'm sorry. All right, so appoint the public defender temporarily so you can communicate. State's gonna, normally, we put that no contact order on unless the judge hears from both sides. You don't probably have any weapons with you, but if you did, you'd submit those to the custody of the arresting law enforcement agency within 24 hours of your release. You qualify for pretrial release, so.
Your Honor, are you going to order a one-time return since there's a separate residences?
Oh, if they are living in another state, I don't know how I can authorize law enforcement up there.
Your Honor, it's still ordered even if it's out of state.
Even though it's out of state? Oh, I don't have jurisdiction in Maryland. So I would just say, if you guys live together, you're gonna need some help getting your stuff out of a shared residence, okay? I can't do extra judicial authority orders, just can't do that. All right. So you qualify for pretrial release, and I guess I need an order saying she's allowed to go back to her home state of Maryland?
Yes, Your Honor.
All right, so they'll keep up with you, make sure you make your court dates.
Are you ordering no alcohol, Your Honor, as there was allegations of alcohol use?
You know, it's too far to,
Usually when they're on PTR and there's allegations of alcohol, if they do no drugs or alcohol without a valid prescription and RUA.
is that standard on PTR?
Yes, Your Honor.
All right, try to stay off the sauce. I don't know how they can supervise you from Maryland, but we'll go ahead and put that down for the record. Yeah, I'm done.
Are you requesting the RUA or no?
State requested. I don't know if judge is going to order.
Are you ordering RUA as the state requested or no?
Are you random urinalysis?
Yes, Your Honor.
There was no, I would just ask for.
It was alcohol.
No drugs were involved, Your Honor.
No, I don't, no, it's, she's fine. Okay. Is this is it Thibault?
Yes, ma'am.
Thank you. All right, then, the case number is 2002-1MM156280. And also, complicating factor out on bond and ROR for 2020 CF 309880. Because you're not supposed to have any new charges while you're out on bond. It's a violation of release conditions. We're going to appoint the public defender to represent you on the new charges, and I'm assuming you already got your lawyer on the old charges.
Yes, ma'am. I go to court in like 4 days.
I can't hear you, sir.
I say, yes, ma'am. I go to court on like the 20th or the 21st for the other.
That is a complicating charge. Well, you, okay,
And I have a paid lawyer for that case, and that case is getting resolved.
okay. It's a good thing you've already got a court date set. That might make it a little easier for you. Okay, so we also have some traffic cases here. Okay, so let me separate these out a little bit. The battery charge that I previously told you the case number, that was a warrant that was signed on March 3rd, which might have predated the charge for which you're out on bond, I'm not sure. And we do have a witness, I guess. All right. So the date of arrest was March 3rd, and he was bonded on March 3rd, 2020 for the drug charge. And the alleged domestic battery was March 3rd of 2021. Seems like March is a very active alleged month for you, but don't say anything. And ma'am, would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay. Are you Miss Peachlin Farmer?
Yes, ma'am.
Okay, so this is an allegation according to the police officer's affidavit for arrest warrant that had occurred allegedly on March 3rd. And the state's going to ask you some questions about whether or not you want contact, whether you're afraid, whether you'd call 911 if anything else happens, things like that. State likes to ask those questions.
Good morning, ma'am. Can you please state your relationship to Mr. Thibault?
He is my boyfriend and my son's father.
Approximately how long have you known him?
4 years.
Has anything like this ever happened before?
No, ma'am.
Are you afraid of him?
No.
Would you be afraid of him if he were to be released from custody today?
No, ma'am.
Do you want to have contact with him?
Yes.
Do you believe drugs or alcohol played a part in that incident?
No, ma'am.
And are you willing to call 911 if anything ever
Yes.
violent happened in the future?
Yes.
Right. Thank you. That's all I have.
Okay. All right, ma'am, I understand everything. I'm sorry we're going kind of fast, but she asked all the questions that I needed.
Okay.
And I didn't see the traffic cases yet, but that's 21 CT 3568 and 69.
Can I say something, ma'am?
That's supposedly from the 16th of May. You might want to, now supposedly, where's the public defender form?
Your Honor, for the case he's out on bond on.
Is your office appointed on that?
On which one, Your Honor?
The one he's out on bond?
The one he is out on bond, 20 CF.
He has a private.
3098, he has a private attorney.
I'm sorry, I was asking the clerk a question. Can you repeat that?
It's the same thing. That's what I'm telling you. You want me to tell you?
Yeah, you can.
The traffic case.
You know, I just want to tell you, you have the right to remain silent. Everything is recorded.
Yes, ma'am.
And you could possibly make a partial confession if you say anything about the facts of the case.
No, ma'am. It's not nothing like that. They said that those charges were going to end up getting because I got hit in a car.
Okay,
I got
well,
hit.
let me look at
In a
it.
car accident. Somebody hit me, but I had the warrant, so I never did anything wrong. The car was still there.
All right, well, I have to still read the police report.
Car was totaled. I couldn't flee.
Let me read the police report. They've alleged a hit and run. All right, let's see. And that's when they found the old warrant, okay. Property owner. Okay, well, so, this, leaving the scene of a crash, if it's determined later that the other person was at fault, that's probably going to factor into how the case is handled, and whether or not they are really worried about it. But you still have a leaving the scene of an accident allegation that they could file, even if the reason you left the scene was not because of the fault, but because of you were worried about the warrant and driving on a suspended license. And this is how things snowball, okay? Like, you just can't run your life this way without it becoming a hassle, a real hassle. So, these charges, they have probable cause for these, all right? And so you're going to have a court date in traffic court. You're going to have a court date in misdemeanor court for the battery, and you're out on bond for the other thing. You got some issues that are they are a result of decisions that you have made. Whether or not you thought you could manage and handle them, it is just a situation, okay? I'm not going to hit you terribly on the leaving the scene because it's mainly because you're afraid. So I'll actually reduce the bond on that to $500 and the driving while license suspended to $100. I also want to tell you on the driving while license suspended, you may think you don't have money. You may think you can't get your license back, but it's time for you to get a second job.
Yes, ma'am.
I'm going to move on and just leave it there.
Yes, ma'am.
You have got to dig yourself out of a hole. You are in a hole. And you're going to have to get your license back and move on. As far as the battery, she's here. She's not worried about it. It's no hostile contact. normal orders are, if you have any guns, knives, or weapons, put those in the custody of the arresting law enforcement agency within 24 hours of the arrest. You're not allowed to have any weapons while you're out on bond for a domestic. It's a different court date. Now you're going to have because of the way that things happen, I would rather it be more efficient, but the way things happen, you're going to have a court date for your traffic case. You're going to have a court case in a separate division for your battery, because we have a separate division for batteries. And now you're out on bond for a felony, and that's the problem. Because those felony judges don't like it.
Your Honor, what are you setting as the bond on the battery?
I couldn't hear what you said.
Or what are you setting as the bond on the battery?
On the battery? Did I say? I didn't say anything.
You haven't said anything?
Oh, okay. I'm just going to go with 250 because I have a sneaking suspicion she's going to be the one bonding him out. I'm having a problem with the felony though, because has anything changed? I mean, he was out on 15,000, but he's going to court on the 21st. So,
Your Honor, the state filed an information in that case. We filed the trafficking, which is an F1, the possession of a firearm by a convicted felon, which is an F2, and the possession of paraphernalia of the M1.
So, sir, you're probably going to sit in jail in for a few days on that, because
I have a lawyer. That's not even. They dropped my F1 to a F2, and they dropped the possession of a firearm to a constructive possession. That's what I'm saying. That case is already.
So remember, I told you you're digging yourself in a hole. I just, these felony judges, they don't play. All right, I'm going to have to no bond you on that, because that is the way I'm used to them wanting it.
Yes, ma'am.
And the good thing for you is you got a court date set up. And so it's not going to take you too long to get back in front of that judge, but you have too many things going on. And you have got to get to the point where you live your life just completely straight. Because you got too much baggage now, and it's going to hit you every time.
Yes, ma'am.
So now is the time for you to make that decision. Good luck to you.
All right.
I know I sound like I'm trying to be everybody's mother, but I can't help it. All right, is this Ms. Vasquez?
Yes.
Oh, we got, are these co-defendants? Yes. Oh, all right. Okay. Okay, so with Ms. Vasquez, we got case number 2021MM3319AO. And then the next person is going to also be Ms. Vasquez, Samantha and Brenda. And I'm sorry I didn't get down to this level of the paperwork when I was reading this morning, but we'll figure it out real quickly. So Ms. Samantha Vasquez's case number is 2021MM3320. They both qualify for pretrial release. And we both have ages. Okay. So I'm guessing we got a mom and a daughter here. And we're gonna appoint the public defender for both of you, but the way that works out when you have two people charged with the same case, basically, is that can we go ahead and appoint conflict counsel now, or do we have to wait?
They have to conflict off, Your Honor. Just you have to appoint the PD on both.
I can't hear a word you're saying.
You'll appoint us, Your Honor, and then we'll conflict.
Later, okay. So later, the public defender makes a motion and gets out of one case, and I don't know which one but when they get out of the case, we appoint a conflict lawyer, which is a lawyer on a list of people to represent you, but they're not with the public defender's office. In case you guys start blaming each other, you can't have the same lawyer, because that's a conflict of interest.
Okay.
Okay, And both of you qualify for pretrial release, maybe. The state seems to like to ask these questions, which I'm happy to allow. But the bottom line is, ladies, that she's going to want to know if it's safe for you to have contact when you're out and whether or not to live together, because I think Samantha's only 18.
Yes.
So I'm going to let the state ask those questions of you each individually.
Okay.
You do have the right to remain silent. Anything you do say about the facts of your case could be used and played back at your trial, so be careful about that. Talk to your lawyers about the factual circumstances. This is just about the conditions of your release.
Madam Clerk, do you mind swearing them both in, since they'll both be testifying in each other's case?
Would you swear to tell the truth, the whole truth, and nothing but the truth, both of you, so help you God?
Yes, ma'am. Yes, ma'am.
Okay, reflect, they both said yes. Thank you. You can put your hands down.
Miss Samantha Vasquez. To your left is your mother, Brenda?
Yes.
And do you want to have contact with her?
Yes.
Are you afraid of her?
No.
Has anything like this ever happened before?
No.
Thank you. And Miss Brenda Vasquez.
Yes.
To your right is your daughter, Samantha?
Yeah, my baby, yes.
Has anything like this ever happened before?
No.
Are you afraid of her?
No.
And do you want to have contact with her?
Yes, because she's only 18 and she stays with us and we support her until she gets a job. I don't want to see her homeless in the street. I go to work every day and I see a lot of homeless. And I forgive her for what she did. I don't want to hold nothing against her. That's my baby. I don't want to see her in the street with a sign, homeless. I don't want her struggling. I just want her to get a job, and if she wants to leave, she could go on her own. You all support her.
Yes, ma'am. Thank you so much.
I just want the best for her. I don't want press charges on her or anything.
Okay.
I know it was the heat of a moment. That's it.
Your Honor, I believe they both qualify for PTR, and given the testimony of both, state has no objection to PTR for both.
Okay. All right, well, no, we see these cases from time to time. We're just going to let you out pre-release, but they do have some rules, so pay attention.
Okay.
And come to your court dates. And like I said, one will end up with a public defender and one with a private attorney that is, has to be appointed. And we will require no hostile contact, that is, no fighting.
Okay.
You don't want to have more cases while you're out of bond.
No, definitely not.
Is the state asking for no alcohol or something? Are you worried about that in this case?
No, Your Honor, I don't believe there was any allegations
Okay.
for drinking. I would just
All
ask for no
right.
weapons.
If you do have any guns, knives, or weapons in the household, put those in the custody of the arresting officer's agency within 24 hours of your arrest. And good luck to you. It's, the Samantha's the child, right? Okay.
Samantha.
So I always told my daughter, whatever you do to me, your daughter's going to do to you. So just be careful about that.
I was telling to the officers.
Good luck. Come back to court.
Thank
'cause
you.
They can't drop it right away. They've got to figure out what's the bottom line on this case, and you need to come to court.
Okay.
All right. Okay, what do we have left here? Traffic?
And arraignments and ROR motions.
Oh, we're going to do arraignments too?
It's in the morning
I guess I'm
session,
running
Your Honor.
late, aren't I? Or is this normal?
We're usually out in the morning session around 10-ish.
Oh, really?
Yeah. It's okay.
Okay. Okay, this is Mr. Del Toro Bruno?
Yes, ma'am.
All right, sir, thank you. This is case number 2021-161343. And the allegation is driving with license suspended, evidently while out on bond for a scheme to defraud case, which you already have a lawyer for, and you're out on bond, you're out on pretrial diversion for that. Okay. Is that a private attorney? Ms. Figueroa is a private attorney, or?
I'm sorry.
Yes, Your Honor.
Yeah, because it looks like you don't qualify for a public defender on the driving with license suspended.
Your Honor, state conveyed an offer of an adjudication credit time served. If he accepts the offer here today, state would be asking for no action on his out on bond case.
Did you just say that if he pleads out, then no bond on the out on bond case? Is that what you said?
I'd ask for no action on the out on bond case.
Oh, either way. Okay. Well, okay. What I need to tell you about the driving with license suspended convictions, sir, if you get 2 convictions, you come back on a third, it's a felony. So that has a potential long-term significant consequence. Are you hearing me?
A little bit. I'm sorry.
Is English your first language?
It's my second one, but I do understand English fluently.
Well, this is really important. If you get convictions on a driving while license suspended, you can end up in felony court and having a felony conviction. And the state's asking for a conviction right now, which is a criminal conviction. And it looks like you might have about 4 tickets. So they're not asking for me to do anything to the other bond. On the driving while license suspended, if you don't take their offer, I'll leave it at $500. I guess I'll let you get back out on pretrial diversion on the scheme to defraud. If you decide to bond out instead of pleading out, then you want to try to get your license back before you go to court.
Your Honor, he stated that's what he would like to do.
Yeah, you don't need to be fooling around with these driving while license suspended convictions. Good luck, sir. Make sure you come back to court.
Thank you, Your Honor.
Ms. Jacoby? All right, this is case number 2021-1010, let's see. Okay, 2021 CT 832AW in Division 85. That person bonded? Sorry. Okay. Okay, well, I thought you told me, well, are you Conrad Radcliffe?
Yes, ma'am.
Okay, thank you. All right. It's case number 2021 CT 2463. In Division 62, it's an alleged driving while license suspended.
Your Honor, I believe that's his leaving the scene failure to appear case.
We can appoint the public defender. Okay. And there's a failure to appear. Is that the one you're talking about? Okay.
Yes, Your Honor.
Failure to appear on a leaving the scene, which is 2021 CT 2463, Division 85. And the driving while license suspended is 21 CT 3566, Division 62. So part of what happens, sir, is you get these cases and you get more than one court date until the public defender can get your cases together in one division. Okay. All right, and this was just a teletype check based upon the tag. And was there a failure to appear on the, leaving the scene? Okay, $500 on that. You have a bond of $500 on the leaving the scene failure to appear. And on the driving with license suspended. Sir, based on your criminal history, I'll leave the bond on that one at $500. Now, you do have a lawyer, and
Your Honor, which one? Are you leaving the scene? You're leaving it at 500?
yeah, Because that was already set by the judge.
A warrant, yes, Your Honor.
Your Honor, on the leaving the scene, he would like to resolve, I believe the offer is an adjudication of guilt, credit time served, and a $250 fine.
Okay, the state's nodding their head.
That's correct, Your Honor.
Okay, well,
There's an offer on the Dwellis as well, Your Honor.
there's a what?
There was an offer also on the Dwellis. I don't know if
Well,
Mr.
you know,
Radcliffe
part of the
is trying to
problem that
take
he
it.
really needs to understand is that, Mr. Radcliffe,
Ma'am?
these cases, if I'm remembering correctly, I've been off of the bench now for several years, but doesn't that also qualify for the purpose of an HTO?
Yes.
All right, so
It
these
does.
cases, you get convictions on 2 of these. If you get charged with driving again, you could be in felony court.
Your Honor,
Because these cases can be used to upgrade any subsequent driving case. And then you'll be coming in here on a $2,500 bond, and yeah, if you get caught driving again. So you know, it might seem easier to you to plead out today and get time served,
Yeah.
but it'll really complicate your life in the future. So if you have any idea that you could possibly get your license situated, even if a judge has to work with you for a while, and you have to get a second job to try to dig yourself out of the hole, then now would be the time to make that decision. I don't mind taking a plea, but I need to be extremely clear with you, because the next public defender, when you get arrested on a felony, is going to listen to the record of this plea and try to figure out if you really knew or not that you were working your way into an immediate felony the next time you get arrested for driving, because that's exactly what will happen.
Your Honor, and I believe that the issue is that my client, if you look, is on Social Security disability. He states he does not have a way to post any type of bond amount, which is why we were trying to resolve it. But I'm going to double check with him again to make sure. Your Honor, he understands that he would still like to resolve it. I did speak with him. He understands that it can habitualize him.
It will. I mean, definitely. So are you offering a time served and a conviction on both?
Yes, Your Honor. And a $250 fine on the leaving the scene.
All right. Sir, if that's what you want to do, raise your right hand to be sworn in to tell the truth. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. So, you know, this might be rational for you. It might be a good deal for you, given the fact that you have prior Dwellises on your record. But you have got to make the decision you're not going to drive anymore, period, because you will be in felony court.
Okay, I understand.
Okay. All right, did you read the plea form?
Yes, ma'am.
You've seen it before?
I seen it when she did. Yeah. Yeah. Yes.
You've seen it before?
Yes.
Okay. So you understand you're giving up all the rights on that form when you plead no contest to
Yes,
these
ma'am.
charges? And that you won't have a trial, you won't have a defense, you won't have the public defender checking through your case for any technical defects in the state's evidence. Do you understand all that?
Yes, ma'am.
And the state will not have to prove beyond a reasonable doubt to a jury of 6 people, all of whom would have to be convinced unanimously that the state proved every element of each of these charges. Nobody will have to prove any of that if you plead and accept these convictions on your record. Do you understand that?
Yes, ma'am.
Are you under the influence of any drugs, medication, or alcohol at this time?
No, ma'am, I don't do drugs.
Okay, are you doing this of your own free will?
Yes, ma'am.
Any questions?
No, ma'am.
Okay. I find that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner, that there is a factual basis for accepting a plea on each of these charges, and in regard to each of these charges, would find and adjudicate you guilty of the driving while license suspended and the leaving the scene of an accident, sentence you to the cumulative numbers of days you've got time served on either one of them. And there's a $250 fine on top of the time served for leaving the scene of an accident, which is the 2021 CT 2463. And both of them, each of them carry court costs, which I'm not sure what that is now. It used to be around 201. I don't know what it is. But, you know, you got extra court costs that get added to the fine. Understood?
I understand.
All right, so if you're assuming you're not going to pay anything off, these will suspend your license if you don't, but I'll give you supposedly up to a year to pay on these if you're trying to dig yourself out of that hole.
Yes, ma'am, thank you.
That's it. Good luck.
Thank you.
You're welcome. Okay. Is this Mr. Burkhart?
Yes, Baron.
Okay. Is that a recall? Oh, these are arraignments.
Arraignments, Your Honor.
Okay, so I guess we'll try to recall him then. Okay, so is this Mr. Manuel?
Are you gonna waive for medical?
The PD wants to waive his appearance at arraignment?
I'll waive the appearance. I'll waive and enter plea of not guilty, Your Honor.
For Burkhart?
Mm-hmm.
Okay.
Yeah, for Burkhart, Your Honor.
All right, what about Manuel?
Oh. Ma'am.
Oh, she's going to give the pretrial date.
Okay, Division 61, pretrial date will be June 28th at 1:30 p.m. in courtroom 6B.
Okay.
I'll waive and enter plea of not guilty.
Pretrial date will be at Division 81, July 2nd at 9 o'clock in courtroom 4E.
All right. Right. Medical? Is the public defender representing him also? He's got 13 days in on a driving while license suspended.
He's all in the back?
Yeah, it's near the back, like 2 on the back.
Okay. I'll waive the appearance and enter plea of not guilty, Your Honor.
The pretrial date will be in Division 80, June 24th at 9 o'clock in courtroom 9C.
Okay, I guess he's got 2 cases. It's 3304 and 3305, so we'll set those together, I think. Right? Okay. Is this Juan Almonte? No. Okay, 2021 MM 2580AO, been in for 33 days. Are we waiving him too? I mean, is everybody
Yes,
getting sick in the jail right now?
Wait, it's all, I don't know what it says. I'll waive and enter plea of not guilty.
Pretrial date will be Division 50,
I don't know.
June 7th at 9 o'clock in courtroom 7C.
I'm sorry, Madam Clerk, do you mind repeating that?
June 7th at 9 o'clock.
Thank you.
The next one I have is a Joseph Barron, so did something already happen? Okay, so, all right, guess we can hear your case next, sir. 2021 MM 230AW, and it's a summons, so we're just telling you about a charge of a battery And to be honest with you, I don't have any information here. It's probably domestic because it's in Division 50.
I'll enter a plea of not guilty, Your Honor.
All right, so assuming you already have a public defender on something else anyway, we'll just appoint a public defender. And what happens is sometimes there are things where people call the police, there was a report made, but you were never arrested. And so when you're in here on something else, we just let you know about those cases and start processing those at the same time.
And your pretrial date would be in Division 50, June 7th at 9 o'clock in courtroom 7C.
No. It's just a summons, but if you bought out on the other thing that you're in on, then you still have a court date. Okay. You're welcome. John, Bill, do we have any more people in the hall, or we just, okay, John Billheimer? Okay. It's case number 2002-1MO439AO. He's been in for 35 days on an open container charge.
Hello.
Hello, sir. I'm guessing it's a time, sir.
Yeah, sure. It's a city case. I've been authorized on the city's behalf to offer a withhold credit time served, court cost, and a $10 filing fee.
Okay, Your Honor.
The right to have an attorney and go to trial.
You would like to accept the state's offer of a withhold of adjudication, credit time served, and I think you said $10 filing fee, correct?
Did you say you wanted a trial, or did you want to have a time served plea?
Time served, please.
Okay, you need to speak up just a little bit. I think I heard time served plea. Okay, sir.
Yes, time served.
All right, would you raise your right hand to be sworn in to tell the truth? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Sir, did you have a chance to see a plea form, or have you seen it before?
I've seen them before.
Okay. She's filling one out right now. Did you want to look at it to make sure that you know what you're signing?
Yes, I will.
Are you familiar with that?
So he reviewed it, Your Honor. He understands all the rights he's given up.
Well, usually time served is the magic word.
Time served.
Okay, so go ahead and sign it, and I'm going to ask you some questions. Okay, sir. And do you understand that you won't have a trial, you won't have a defense, and nobody will have to prove you guilty of this charge?
I understand.
Any questions?
None.
Okay. I find that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner. There's factual basis. Will accept a plea of no contest, withhold adjudication on the charge of open container, sentence you to time served, 35 days, the $10 filing fee, and the court cost payable within a year.
I understand.
Okay. Thank you, sir. Okay, the next case is Mr. Jason Cruz, and it's case number 2002-1MM1269AO. Mr. Cruz has been in jail for 86 days on a petty theft charge. Were you all wanting to resolve it, or do you need to go to trial?
Your Honor, I believe the offer is adjudication of guilt, credit time served, and no return to Walmart, and a cost of investigation of $119.10 to
OPD.
Orlando Police Department. And Mr. Cruz did review a plea form, and he would like to resolve the case today, Your Honor.
Okay, so he's in on a second-degree misdemeanor, correct? And I think I can assume a factual basis because somebody found probable cause originally, but he's, okay.
Yes, Your Honor. We did file an M2 petty theft.
All right. Sir, would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth? Yes. Okay. And if, just speak up a little bit because it's hard for me to hear in here.
Yeah.
Okay.
Yes.
Now, did you get a chance to read the plea form or have you seen it before?
Yeah, I read the whole thing.
Okay, thank you. So when, I'm sorry, did you say adjudication or withhold?
Adjudication, Your Honor.
All right, so an adjudication on a petty theft, I don't know if you've had one before. I assume you had something on your record because you weren't able to bond out. But these petty theft charges can become felonies eventually if you've got 2 convictions and you come in for a third, which might have already been the case because it got filed as a second degree, but you know.
Yeah, I understand.
They add up on you. Do you understand that part?
Yeah, I understand.
Okay. So this will be qualifying you for possible upgraded charges in the future. Did you understand that you would be giving up all of the rights that are listed on your plea form?
Yes.
You won't have a trial, you won't have a defense, nobody will have to prove beyond a reasonable doubt to a jury of 6 people, all of whom would have to be convinced that the state proved it, every element of the charge before you could be found guilty. You're giving up all those rights. Do you understand that?
Yes.
Not under the influence of any drugs, medication, or alcohol?
No.
Doing this of your own free will?
Yes.
Any questions?
No.
Okay, all right. It appears that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner. I'm assuming a factual basis because probable cause was previously found. Will accept your plea of no contest, find you guilty of the charge of petty theft, sentence you to the 86 days you've already served, release you as to this charge. It requires a no return to that Walmart. They're going to have a trespass warning out anyway. The cost of investigation to OPD is $119.10 plus the court costs.
Okay.
What are those, around 201 still, or are they more? 223? 300? Their court costs are up to 300 now? Inflation, okay. So we'll give you a year to pay that. You can always make partial payments, and when you don't pay your fines, in Florida, we suspend your license. So be aware of that. Good luck.
Thank you, I appreciate it.
You're welcome. Okay, you don't look like Erica.
No.
Okay, is she medical?
Colin.
So you just want me to find,
Rosario. Erica?
oh, his name is Rosario?
No, I'm asking them.
My name is Colin Edward Smith.
Okay, so we have, we don't have a Smith. You're Mr. Smith?
Yes, ma'am.
Okay, we have everybody but you.
Colin.
I believe
It's a VOP.
VOP, Your Honor.
Okay,
I'll enter a denial.
all right, so you might as well tell us the case number because we don't have the paperwork up here.
21 MM1153 Colin Smith. It's a petty theft, M2. That is a VOP.
She's got a Colin Smith.
We already had a date set.
All right, so you want to tell them what the date is?
It's June 9th at 9:30, 7C.
Okay.
Division 63.
All right, he's already got a PD, right? Okay, you got a court date.
Okay, so, but I can't bond out, so I just stay in the jail until then?
Well, oftentimes on a VOP. Huh?
It's not showing the PD.
You don't have a PD?
Can you appoint us, Your Honor? I'm not sure.
I was here on Thursday and I was appointed a PD,
Oh, yeah.
no bond.
On paperwork. Yep.
Okay, so, well, you got a PD. We just verified that you have a PD, and I'm sorry if we caused you any confusion on that. If the judge before whom you had the probation set it at no bond, normally I would leave it there. I don't have any basis to second guess that judge. And it is not unusual to come in no bond if it's a violation of probation.
Well, I had actually asked my probation officer to violate me so I could come to jail and just do the time instead of doing the probation.
Okay,
Is that
well,
possible?
well, yeah, but, we might not operate as quickly as you would prefer, and your court date is June 9th. So you're gonna be in here for another,
3 weeks.
I guess.
Okay.
Now, you do have a public defender, and if they actually come and just visit you, and they know you want to plead, and they can contact with the state, and they can contact the probation officer, and everybody can agree, maybe they can get you in faster, but that does, take some extra initiative.
Okay.
I wish we didn't have such a high-volume court, but we do.
Yeah. Okay, so I just have to wait till June 9th?
Probably.
Okay. Thanks.
You're welcome.
What happened to Erica?
Erica Alfaro, she's medical.
Della Rosario.
Is that a medical? We have a Erica Della Rosario Alfaro.
She was medical.
She was medical. Okay, and that was a petty theft. She's got 17 days in. Does she have a public defender?
Yes.
She does.
Your Honor, I'll waive and enter a plea of not guilty.
Okay.
Pretrial date will be in Division 85, June 14th at 9 o'clock in courtroom 4A.
Is this Mr. Dodd?
Yes, ma'am.
Okay, thank you, sir. It's case number 2002-1MM3041AO. And this is something that was filed as a criminal mischief, and you probably did not get arrested on it, but it's out there, and since you're in jail on something else, they're gonna, bring it up and let you know about it.
Yes, ma'am.
Your Honor, he has another case as well.
Oh, is this the second piece of paper here? Okay, and then you have also another one, which is also a summons, and it is case number 2002-1MM3047. They're similar numbers, so I don't know, they might be close in time, which is a battery. So, and the 3041 is in Division 82, the 3047 is Division 84 right now. Should we appoint the public defender, or did we already?
I don't believe so.
Okay, so you have the public defender on your other charges already?
They gave me one, but they took it off and gave me something called a regional counsel.
Oh, he has.
He has RCC.
Regional, should we appoint regional on these then also, or do we have to wait?
Again, I think you have to appoint the PD and let them.
Appoint us, Your Honor, and then we.
All right, okay. I used to be able to clear it all up at one time, but I guess. All right, so, Mr. Dodd, you have a couple charges that you may or may not have, know what they're about, but, and you probably are going to end up getting the same regional counsel on these, but we can't do it yet because the paper flow
Yes, ma'am.
takes more time for that. So you might want to inform your regional counsel that they also have a couple misdemeanors to deal with.
I was gonna give them a pretrial date.
And we had to give them 2 different pretrial dates also? Okay.
Pretrial date for 3041, Division 82. It'll be June 14th at 10:30 in courtroom 10B. And 3047, Division 84, pretrial date June 14th at 9 o'clock in courtroom 4B.
So that lawyer will know what to do with it, but it takes a little while for the paperwork to get to him. So if you can help the lawyer find out about the new charges, that might be helpful to the lawyer who can look it up online.
Do I have a bun on anyone else?
Did we have that on the paperwork? Oh, no, they're summonses. So the summons means that it was just out there that if they had been able to give you the summons, they would just tell you the court date to appear. So you're not being held on those.
Okay, then, thank you.
All right, you're welcome. All right, I guess that's all for, oh, no, we've got more? These are the release on, these are the 33-day motions? Okay.
Would you like me to announce, or would you like to announce?
Yeah, go ahead, because you probably are going to roll through it faster than me.
Janine Scaglione, 21 CF 4114. It was a notice of non-filing.
Okay, so the motion for release on own recognizance is granted.
Granted, yes, Your Honor.
Is this the 16th?
17th.
17th, thank you.
Donald Ozell Smith, 21 CF 3961. It was filed on the 14th, so denied.
All right. That motion for ROR will be denied. Thank you, counsel.
Samuel Cunningham, 21 CF 4283. Notice of non-filing.
Motion for ROR is granted.
Sarah Jones, 21 CF 4110. Notice of non-filing.
Motion for ROR granted. Thank you.
Ashley Inabit, 21 CF 2959. Notice of non-filing.
Non-filing, it's granted on the ROR. Thank you.
Winston Sharp, 21 MM 2378. A no information notice was filed.
All right. Release on recognizance is granted.
Andrew Byington, 21 CF 4131. Notice of non-filing.
Okay. ROR is granted. Thank you.
Suleiman Nee, 21 CF 4214. Notice of non-filing.
Motion for ROR granted.
Irvin Royal, 21 CF 4321. Notice of non-filing.
That was a non-file?
Yes, ma'am.
Thank you. Motion for ROR is granted.
Jennifer Witt, 21 CF 4286. Notice of non-filing.
Motion for ROR granted.
And Samuel Cunningham, 21 CF 4284. Notice of non-filing.
Motion for ROR granted. Thank you. Okay. So I've been informed that you all want to have lunch break, but I was going to ask you what you wanted because it doesn't matter to me, and you guys need to have a break. And I'm fine. I'm retired. I don't care when I come or go.
We generally start second session at 1. I don't know if that gives everyone enough time since it's already 12:30.
Is that what you all want? Should I take a vote?
One is fine with me.
Okay. 1 o'clock, because nobody's saying otherwise. I mean, I'd be happy to give you more. Thank you. We'll be at recess. Oh, no, let's not appoint the PDs on the ones we pled. Because she doesn't want them to have to pay for that. Probably.
Yeah.
Okay, cool. All right, just normal and on record. All right, going back on the record for the afternoon session at BRC, Judge Bleckman. Here, do the lawyers you need to tell your names to the court reporter?
Yes, Your Honor. Taylor May on behalf of the Office of the State Attorney.
Letitia George on behalf of the Office of the Public Defender.
Okay, thank you. All right. Thank you all. Is this Mr. Davis?
Yes.
Okay, thank you, Mr. Davis. We have a misdemeanor. It's case number 2002-1MM331680. And the allegation is trespass after warning. It's currently going to Division 62. And you can get a public defender if you want one. Now, would you like to know what the state's recommended penalty would be if you accepted the charge?
Yes, ma'am.
Okay,
The offer conveyed, Your Honor, was an adjudication, credit time served, no return to hometown studios, and to abide by the trespass warning.
abide by which?
The trespass warning.
Okay.
We would like to accept the state's offer, Your Honor.
Okay.
Ma'am. I ain't fixing it. I don't see well. So you just tell me that's something.
Okay, Your Honor, he would like to accept the state's offer here today.
Okay. Sir, go ahead and read. I'm sorry, you were waiting for me. I thought he was talking to you.
He was, Your Honor. I was going over all the rights he has.
All right. Okay, so would you raise your right hand to be sworn in to tell the truth, Mr. Davis? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. Now, I think that was a yes, but would you do me a favor and just talk a little more loudly through the mask?
Yes, ma'am.
Okay, you could put your hand down, sir. All right, now, so Mr. Davis, I think you're familiar with that plea form because you've been in court before. Am I correct?
Yes, ma'am.
Okay, so you understand this would be another criminal conviction on your record?
Yes, ma'am.
Okay, and do you understand that you would be giving up all the rights on your plea form if you plead no contest?
Yes, ma'am.
You won't have a trial or defense, nobody will have to prove it, okay. And are you doing this of your own free will?
Yes, ma'am.
Okay. Sir, I find that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner. There's a factual basis. We'll accept your plea. Find you to get you guilty of the charge of trespass after warning. Sentence you to the, was it 2 days? Time served, whatever you got?
2 days, Your Honor.
2, and thank you. Release you as to this charge. The court costs, I think the clerk told me they were like $300 or something now, court costs. But we just give you a year to pay along with all your other court costs. Good luck, and I guess we're not appointing the public, you want to be not appointed because it's just extra?
Yeah, I'm just helping.
Okay, thanks. Just want to clarify what we're doing now. All right, good luck, sir. Is this Mr. Timothy Lyman?
Yes, ma'am.
Thank you, sir. Okay. Okay, so you have a warrant for a possession of methamphetamine. that was set at a $250 bond by a judge who read the affidavit for warrant, and it was in relation to an incident from April 21st in the area of West Colonial Drive in Cordova. So the officer didn't arrest you at that time. Is this in the misdemeanor pleables?
No, Your Honor, this is a move up.
Oh, okay. So the bond is $250 right now, but we can appoint the public defender to represent you, sir.
Yes, ma'am.
All right, good luck.
And Your Honor, for the record, that was 21 CF 5079.
Oh, did I not say that? Thank you.
It's okay.
Yes, that's for the record. Thank you. Okay, Yvonne Murillo, thank you. Okay, ma'am, this is case number 2021 CF 5703AO. Okay, we've got move-ups before the misdemeanors. Okay, things are a little different. Okay, ma'am, the allegation was battery on a firefighter. It's going to Division 19. Public defender is appointed. Okay, looks like a little bit of a drug problem, but, so are these at 2,500 now? Because I'm used to 1,000.
Yes, Your Honor. Due to the enhanced nature, due to it being a battery on a firefighter. And state would ask that you stay the bond.
Your Honor, I believe that my client was it appears under some type of substance at the time, so I ask that you take that into consideration. I don't see an extensive criminal history that is violent, so I just ask that you.
Looks like the main problem is she's got a drug problem.
Correct, Your Honor.
She does have 4 prior battery DVs. And then this battery on a firefighter, Your Honor, so I would just argue that she does have prior batteries, even if she was under the influence of a substance. The law enforcement officer and the firefighter were trying to help her.
Yeah, well, I don't blame him for filing a charge, and I don't know how far it'll get as far as a specific intent crime, but I'll set it at 1,500. I'm just going to cut the baby in half and compromise it. Ma'am, make sure you come back to court for your appearances and talk to your public defender. You're starting to get a bit of a history, so at some point, it could cost you some real jail time if you don't get a handle on it. Good luck.
Your Honor, are you going to do a no contact with victim or witnesses?
No contact with the alleged victims. Okay, thanks. Oh, is this what we did before? You want me to sign it right now? Oh, okay, thanks. Appreciate it. Okay, now we have the misdemeanor pleables. Mr. Blake?
How you doing, ma'am?
Okay, thank you, sir. So we have, in this case, a 2002 1 MM 3331, which allegedly has a petty theft of resisting without violence and possession of drug paraphernalia on it, with some prior criminal history. If you need the public defender, then they can be appointed. It's currently headed towards Division 62. Now, the state might have offered you a way to resolve the case.
Not at this time, Your Honor.
Not this time? Okay. So, well, sometimes, Mr. Blake, if you have some prior convictions and they think they can upgrade it, they might not be wanting to resolve it right now. It appears that they have enough information to file the charges. Let's see, there's a resisting, where's that? All right. They're a little bit short on the PC, on the resisting. I think they have a conclusory allegation on that, which I'll just take into consideration in regard to the bond. All right, Mr. Blake, so let's leave the possession of paraphernalia at 500, the petty theft at 100. The resisting at 100. Appoint the public defender. If you bond out, make sure you talk to your lawyer. You get a little history that's starting to complicate. No, I didn't put 500 on that. It's put 100. It's subsidiary, but I put 500 on the paraphernalia. Okay, thanks.
Your Honor, is there a no return and no contact?
No return to that particular store or contact with the witnesses. And that's all we'll have for you at the moment. Thank you. Is this Mr. Bakari Edwards?
Yes, ma'am.
Okay, sir. Okay. So this case is case number 21MM3324, has a trespassing and a possession of drug paraphernalia, and evidently there's a first appearance detainer for 2020CF1496580 because of being out on ROR for that. And we can appoint the public defender to represent you, sir. Are you all trying to resolve the misdemeanor when he's out on bond for the felony?
No, Your Honor, I didn't convey an offer at this time because I believe additional charges are going to be filed.
On the misdemeanor?
Yes.
Okay, sir. If they find any substantial amount of drug that was left in the paraphernalia, maybe they would file some more, but at the moment, we'll find probable cause for trespass and set the bond at 500 and 100 on the paraphernalia and appoint the public defender. That's going to Division 62. In regard to the possession of methamphetamine that you were out on bond, we used to do is revoke them and set bond at 2,000.
Yes, Your Honor, that's what I was asking.
Pretty
is
standard still.
Revoke and set a higher bond.
Right, so because when you're out on bond and you get a new charge, it's a violation of the bond. So I'm not going to revoke it totally, but set a higher bond on the felony. Right.
Your Honor, in the underlying case, can you order a no contact with the victim in the case?
Okay, on the trespass, no contact with the witnesses and no return. Thank you for keeping me straight on these.
I'm sure by the end of the week, you'll have it perfectly straight.
I don't know. It's been a lot of years.
It's hard to get back in the swing of things out here.
I think I've gotten too relaxed. Mr. Pemberton?
Yes, ma'am.
Okay, sir, thank you. We have case number 2002-1-3327, which is alleging possession of drug paraphernalia and soliciting without a permit. Evidently, you might have been out on bond for a felony possession of cocaine on 2002-1CF692. So that's and possession of methamphetamine in that particular case. The new case is going to Division 82 if you don't resolve it. You could get the public defender if need be. Are the parties trying to resolve this one?
Yes, Your Honor. I did convey an offer, an adjudication credit time served as to the soliciting, and a no information as to the drug paraphernalia. May I approach?
Okay.
And Your Honor, he would like to accept the state's offer
Okay.
here today.
Thanks. All right. All right, sir, would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you could put your hand down. Now, so since you're resolving the new one, do you want to take no action on the out on bond, or?
Yes, Your Honor, state requests no action since he's resolving this case.
Okay,
Accept.
all right, no action on the out on bond. So, Mr. Pemberton, that probably sounds like a good deal, I guess, to you. Have you read the plea form?
Yes, ma'am.
Do you understand that you would be giving up all the rights on your plea form?
Yes, I do.
You won't have a trial, you won't have a defense, nobody will check out your case for technical defenses. But you'll have it on your record as a conviction. You understand that?
Yes, ma'am.
Any questions
No.
on this? Okay. So that was a shaking of the head, looked like a no. So, sir, it appears that you are alert, intelligent, you know what you're doing, you're entering a plea of no contest on the soliciting without a permit. The state's dropping the possession of drug paraphernalia charge.
Yes, ma'am.
Okay, so we'll find adjudicate you guilty of soliciting without a permit, give you credit for the days you've already served.
2 days.
2 days, thank you. And then the public defender's not going to request, I think, a public defender appointment fee, but I understand the court costs are up around $300, and we give you a year to try to grapple with those, so you don't get another suspension on your license for
Yes,
failure to
ma'am.
pay. All right. Good luck.
Your Honor, for the record, state announces a no information as to count 1 of 21 MM 3327.
Thank you. Is this Mr. Charlie Will Riley?
Yes, ma'am.
Okay, thank you, sir. We have case number 21MM94AE, an alleged trespass, and there's a first appearance hold for possession of methamphetamine and 2002-1 CF 2445AO. With some history in the background of convictions, but you could get a public defender if you need to on the new charge. Sir, no, they might have talked about it. Is this one that you all are trying to resolve?
Yes, Your Honor, state did convey an offer of an adjudication, credit time served, no return to the Wendy's, and to abide by the trespass warning.
And, Your Honor, he would like to accept the state's offer here today.
Okay. Are we taking any action on the out on bond?
Your Honor, since he's resolving this case, they would request no action.
Okay. All right, Mr. Riley, is that what you want to do? Okay, then you'd raise your right hand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth? All right, thanks. I should mention that since you are going back to court on a felony, that, they'll might see this, and I don't know if it'll affect how they feel about the penalty on the new one. But, they can see all this. Do you understand that? Okay. Have you had a chance to look at the plea form? You understand that you would be giving up all the rights on your plea form? You won't have a trial or defense? Nobody will have to prove it beyond a reasonable doubt? Okay. It appears that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner. There is a factual basis for the plea, and so I'll accept your plea of no contest on the trespass charge. Find adjudicate you guilty in regard to that charge. Tell you to abide by any trespass warning at that Wendy's and tell you not to return there. The court costs are approximately 300 something, and we'll give you a year to work on paying that. Yep, that's all we need. Thank you. Thank you. Is this Mr. Schiavone? Okay, sir. Thank you. We have case number 21MM332380, an alleged criminal mischief. And I don't know if there's still an issue about the ID or whether that would impact everything. Let me know if there is. The allegation is criminal mischief. It would be going to Division 81. You could qualify for the public defender if you wish. Sir, is this one that the parties are trying to resolve today?
No, Your Honor, as it's a true victim case.
Oh, okay. Right, and it looks like he actually lives in Connecticut.
Actually moved down here 3 months.
You moved down here?
Yeah, I just had a rocky start.
Right. Didn't change your ID yet. Don't say anything about the case yet, because it's all being recorded. Okay. Okay. Well, sir, state is generally going to want to speak to the other party before they make a plea offer.
Yes, Your Honor.
Which may or may not make a whole lot of difference on a misdemeanor, but they're entitled to that. So we'll appoint the public defender. It appears that a $500 bond would be fairly normal. And I don't know about this ID hold, sir. That is something where when the jail is trying to book you out, so to speak, they might need positive ID or something.
Yeah, he's been positive ID, Your Honor.
Okay, all right. Thank you. They've got that cleared up.
So, Your Honor, that was a $500 bond. Can that state request a no return to the business as he's been terminated from there and no contact with the victim?
Thank you for reminding me. Do you understand that, sir? The no return and no contact with the alleged victim who's now a witness, so you need to just, not have contact with them unless the court was to hear from them and to know that it was okay.
That's fine, Your Honor. I had a question in regards to the $500 bond. Is there any way I can, by any chance, ROR, because I don't have any money to put up $500. I have nothing to pay for the bond. Otherwise, I'll be sitting in jail waiting for this to get resolved.
Your Honor, I don't believe he qualifies for an ROR due to his history from Connecticut.
Yeah, I was looking at the history, and that's where the problem is arising.
Well, I'll do anything just so I don't have to, I'll do anything I can just not to sit in.
I guess the way I've dealt with it philosophically over the years, which was a lot of years, like over 40 now, but, if you haven't aggravated your family, you probably could call somebody,
My family passed away. That's the thing. A lot of my family members passed away, Your Honor.
Your Honor, in an attempt to help Mr. Schiavone, I don't believe he was screened for PTR. I don't know if he would otherwise qualify. I don't know if you want to order.
He was screened. He didn't qualify.
Okay, never mind then.
All right, let's put it at 250 and see if you can't find some acquaintance or friend.
All right, thank you.
Good luck. Is this a Christian law? Is that you?
Yes, that's me.
Okay, sorry, I'm having a hard time hearing with the printer is really loud up here. Okay, so, you got a warrant here on a failure to appear, 3 different counts. Originally, I guess, being in the park and camping, and failure to identify yourself. So they call those non-pleable. Well, yeah, you did. You might have gotten released and then, forgot to show back up. Now, we call them non-playables, but I don't know, there's not like a legal impediment to pleading.
Yes, Your Honor, it's a non-playable just because it was a failure to appear. A state did convey an offer to
Okay,
Ms. George of a withhold, credit time served, no return, court costs, and a $10 filing fee on behalf of the city. That's what the city's authorized me to do on their behalf.
okay.
And for the record, I believe this is 21 MO 257.
Oh, did I not say what that was? I'm sorry. Thank you.
That release didn't even happen until like February. I got arrested in October and then got released in February. It's impossible for me to return then.
So, sir, sometimes you got a warrant out, and I haven't checked up the records that
I don't want a public defender, would you say?
you want a public defender?
He doesn't. Oh. Your Honor, I believe there may be some mental health concerns. So I was just.
Ain't no mental health. Just because I told you to move, I didn't want no public defender. Did I tell you to move? I ain't got no mental health concern.
Based on the notes that is in our system, Your Honor, from the case that she has a KPS on, I would just ask that you set the bond amount because there may be some mental health concerns.
There ain't no mental health concerns. If you just most brokest black bitch I ever met, quit collecting a fake ass check, you old dumb bitch. Fake ass check, drug dealer, bitch ass bitch.
Okay.
Ain't nobody trying to collect no fucking fake ass check.
Your Honor, as it
I
is
have a feeling she's going to be back tomorrow.
Right.
As it is a
She has-
failure to appear.
Yeah, she has multiple.
Well,
stakes
she's
in this
confused.
fire.
You know, what happens is people get let out on ROR or something, and they think the case is resolved. And then, you know, I was going to explain that to her, but she got aggravated, so I didn't interrupt.
Yes, Your Honor. I don't know if it's appropriate to screen her for mental health PTR and then otherwise stay the bonds.
I'm pretty sure they don't want her because, you know, she just threw a fit, and she's probably fixing to get a battery on law enforcement officer if she's not careful.
Yes, Your Honor. State would just ask that you stay her bonds. She's already shown that she's.
Yeah, I'd stayed the bond, and you guys see her in arraignment, I guess, in a couple weeks or something.
Your Honor, are you going to appoint a PD on her
Oh,
behalf?
sure, absolutely, and she probably does need to be screened. I mean, there might be a competency issue, right?
We're already.
Are you?
Yeah, we're already appointed.
That was on Ms. Law.
Yes.
Yeah, the notes do say contact mental health prior to release, so she probably needs to be screened. I don't know if she's going to be competent necessarily, because it would take some time, at the very least, to convince her that this case still exists. All right. Yeah, well, not for mental health pretrial release, but I'm really basically, I think, suggesting to the public defender that they get someone to come and look at her. Because they're, you know, once they determine that the person has a competency issue, by the time they get two doctors to look at it, you're 90 days down the road. And, you know, because it might be a mental illness, she might be bipolar or something.
Yep, they're already working on it, Your Honor.
Okay. Because, yeah, these, you can spend 90 days in jail just because you're bipolar. All right. Is this Miss Jones?
Yes, ma'am.
Okay.
Yeah.
We have city charge. Where's the court case number? 2021MO 579AO, Division 82. You could get the public defender if you need him, ma'am, but they might be trying to resolve this one.
Yes, Your Honor. I conveyed an offer on behalf of the city of a withhold credit time served.
A withholding credit for time served?
Yes, ma'am.
Okay. So the charge is possession of an alcoholic beverage, open container type of charge. Thank you. Did you want to take the time served offer?
Yes, ma'am.
Okay. Would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. You can put your hand down. Okay, so, ma'am, did you get a chance to look at the plea form, or have you seen it before?
Yes, ma'am, I just read it.
Yeah, okay. So you understand that you won't have a trial, you won't have a defense, you'll be giving up your right for them to have to prove it beyond a reasonable doubt to a
Yes,
jury? Doing this of your own free will?
Yes, ma'am.
Okay. I will find that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner. There's a factual basis for the charge. Will accept your plea of no contest, withhold adjudication on the charge of possession of open container. Did you say there was a $10 filing fee on this?
No, Your Honor, only on the city cases that they've already filed on.
Oh, okay. All right, so we'll withhold adjudication, sentence you to the time you've already served, probably 2 days. 2 days. Okay, and we're not appointing the PD because they want to waive their appointment fee, I think. The court costs are about $300, man. We'd give you about a year to try to work on that before we suspend your license for failure to pay.
Yeah, I can work on the court costs. You said 300, that's okay.
Something like that. I mean, they didn't even, things change and I'm just substituting in here, but
Yes, ma'am.
yeah, and the clerk can give you better information about it, but they will take partial payments, I believe.
Yes, ma'am.
Good luck.
Time served on.
Okay. Is this Mr. Charles Darnell White? All right, Mr. White. I think we've got 21MO580. Public defender is available if you need them. And the allegation is open container, which looks like they have enough to file the charge. Are we trying to resolve this one?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold credit time served.
Okay. All right, sir, you could get a bond or something like $250, but if you want to get time served, you can plead no contest.
No contest.
Okay. Are you looking at one of those plea forms? Okay.
I understand.
Okay. All right, then you could go ahead and raise your right hand to be sworn in, or any hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you could put your hand down. So, sir, if you've had a chance to read it, you'd be giving up all the rights on the plea form, including the right to have a lawyer appointed, the right to have a trial, the right to have a defense, the right to see if the state could prove it or not beyond a reasonable doubt to a jury. Do you understand those rights?
Yes.
And you're willing to give up those rights in order to finish your case today?
Yes, ma'am.
Okay. Withhold of education still shows up on your record, and but it looks like you are alert, intelligent, that it's probably in your best interest to get the thing over with, and there's a factual basis. I'll accept your plea of no contest. Withhold adjudication on the charge of possession of open container, sentence you to what?
2 days.
2?
2 days.
2 days time served, thank you. And there's court costs that are around $300. We'll go ahead and give you a year to pay that. When you don't pay your fines, they suspend your license.
Okay.
Good luck. Is this Mr. Williams Flags?
Yes, ma'am.
Okay. All right, sir, this is case number 2021MO581AO, Division 83, and you could qualify for the public defender if you need them. The allegation is disorderly conduct, and there is some criminal history. Our lawyers want to resolve this one today?
No, Your Honor, I would just ask that you set a bond in this case.
Okay. They never identified the other guy. So are you worried about the alleged victim?
No, Your Honor, not at this time. The officer observed it. It's not a victim case. The officer observed it.
Okay, and you don't want to enter a plea because it's not because, oh, he's on state probation?
Yes, Your Honor.
Oh, that's a problem. Yeah, okay, sorry, I just saw that. Sir, you can't probably plead out because you're on probation, so you need to talk to your lawyer.
I'm gonna be sitting in here for a while.
Yeah, basically, when you're on, and you're young, you're only 23, so, I don't know where that history came from, maybe juvenile court, but when, when you're on state probation, you can't even step on a crack in the sidewalk, pretty much. So, yeah, you might as well just chill out and relax. And start making some different decisions in your life.
So basically, I'm probably gonna go to prison.
Well, I don't know about that, sir, but you're getting awfully darn close, and you probably don't want to go there.
What criminal history are you talking about?
Well, I want you to be careful about talking, all right? Because you're young, and probably a little bit, you know, possession, bat Leo, introduction of contraband, paraphernalia, controlled substance, petty theft, battery, assault, 7 felonies, 8 misdemeanors. And you've already been to DOC, so I guess you'll be going back.
Your Honor, state would just ask that you stay as bond.
Good luck, sir.
What's the bond amount?
$250.
What was it, $500?
$250, Your Honor.
$250, all right, whatever. He's on that DOC hold. He's not getting out on that bond.
Are you going to appoint a public defender, Your Honor?
Oh, let's appoint the public defender on that. I basically had said he's eligible, but we'll go ahead and appoint him.
Hey, bro, watch out, bro.
Oh.
Jesus.
So the next name I have is a Jessica.
Behavior, be honest.
Okay, so maybe that's a reset tomorrow.
Minutes.
We don't have a PD form on her either. Do you want to just reset her?
Your Honor, she's behavioral. I'll waive the appearance.
Okay, let's see. Appoint the PD anyway. It's case number 2021 CF 5709AO, Division 12, and she's got some charges on there. Counsel, what are you all doing on these anymore? I mean, I see the one trafficking in fentanyl.
Yes, Your Honor.
For 100,000.
Yes, Your Honor.
And I used to go along with that back in the day, although I think it's pretty extreme.
Yes, Your Honor.
It is.
What we've been doing is staying the bonds generally.
And letting them deal with it downtown?
And letting the trial division do a bond hearing to see if there's anything more reasonable. But
Right,
as that's
so-
what the bond schedule.
So there's nothing much to be done with the subsidiary ones, all the 5,000 and 4,000 and blah. She really did have a bit of a,
And I would just argue, Your Honor, it's in your discretion to change the bond amounts. Even though they come in at $100,000, majority of clients can't afford a $100,000 bond. And
here's the thing, I don't know what they would do with it anyway. I have a feeling you end up with some kind of bond hearing. So, why don't we just let it all slide and go down there? Because it's like, and she's young, and she was carrying a veritable pharmacy in her car. So, let's just stay the bonds and let that judge decide whatever they're gonna do with it. But we'll appoint the public defender notwithstanding her not filling out the PD form.
Okay, Your Honor, so you're staying count 1 at 4.
Oh, you want me to say them out loud? Okay. All right, count 1 is 4,000, count 2 is 5,000, count 3 is 100, count 4 is 1,000, count 5 is 1,000, count 6 is 1,000, count 7 is 100. Because they'll do something with it, and maybe her parents will actually come and tell
Your
the
Honor,
judge what to do. Well, yeah, did I say, no, count 3 is 100,000. Oh, I said 100, but I meant 100,000.
Your Honor,
Sorry.
can I also request no drugs or alcohol without a prescription and no weapons?
Okay. Is this Mr. Atkins? Okay.
I was coming to get a hold lifted so I could bond out.
Let's look at it for a second. Okay. We have case number 2002-1 CF5714, possession of controlled substance, and a detainer on 2020 CF 1402380, which was grand theft, fleeing attempted to elude, criminal mischief, and that's in Division 11 with a public defender. And I was looking at the bond amount that he's out on bond for. Was that 2,100 or 21,000?
1,000.
21,000? Okay, well, Mr. Atkins, if the felony judge had you at 21,000, that means they probably don't want me to let you out.
No, it was.
No, well, maybe you want to talk to the public defender about it, because be careful. But that's a really high bond. And we'll appoint the public defender. I mean, I could just stay the bonds on the ones we've got now, 1,000 on count 1, 150 on count 2, and that's on
Yes, Your
2021 CF 5714.
Yes, Your Honor.
Going to Division 20 now.
Your Honor, I'll just bring your attention to that. He had approximately 10 grams of the MDMA on his person, which I believe may be a trafficking amount. So I believe the officer
Really?
didn't appropriately
Is that-
charge it.
Your Honor.
Let's see. Oh,
It was separated. It wasn't found together, Your Honor. And I would just argue the officer charged as possession of a controlled substance, so I ask that you leave it at the $1,000 bond amount.
Even if it's found separately, it can still be aggregated to the total amount that was in his possession, as it was all in his possession, either actually or constructively.
well, let's
However, I
think
bel-
about this sort of globally. Being that he's out on bond, and it was a high bond in the first place, and it could be wrong with this, but generally speaking, there's a reason for that, which, I haven't looked at that court file to know. Say I double that one, that sort of takes care of the issue.
Your Honor, I believe, I went back and looked at the statute. I believe it's 14 grams to make it
No,
an
Trafficking.
enhanced amount.
it was all separated. I'm sorry.
I
Be
believe it's
careful, you
14.
could accidentally incriminate yourself by talking about the facts of the case, sir, and you've got too many things pending to take that risk.
The other cases have been filed on.
But I believe 14 ounces were turned into a trafficking amount, Your Honor, so I do believe it was charged correctly, at least for MDMA. But I would ask that you revoke his out on bond, as he was out on bond in, it looks like 4 counts when he picked up this new count, and the condition of being on bond is not to commit any new law offenses. And he was found with a significant amount of drugs.
I was tempted to double them, although I don't know, do you have the individual amounts for the one he's out on bond for?
I believe it was 5,000 on the grand theft motor vehicle. I believe it was 15 on the fleeing and attempting to elude. It was 500 on the criminal mischief and 500 on the petty theft.
Okay. So if we double each of those, I think I would be consistent with what the felony judge would expect. At least I would not be way out of line. But we'll appoint the public defender on the new one. I assume you've got a public defender on the old one. And if they haven't filed it yet, your public defender will know what to do in regard to that.
I have a bond on the.
You have a bond on everything, although I doubled your old one. Because if I do anything less, that felony judge is potentially going to be aggravated with me. All right.
Madam Clerk, do you need the amounts for the out of bond case?
Can you write the amounts for me?
So I wrote down what she told me. She's got it. Okay. Thank you for all that.
And Your Honor, can I request no drugs or alcohol on the new case?
Sure.
Your Honor, can you?
Just say no. You guys are too young to understand the relevance of that. You weren't even born when Nancy Reagan said that.
You want me to repeat them?
Say no, young man. Don't do those drugs.
So for the out of bond case, 10,000 count 1, 30,000 count 2, 1,000 count 3, 1,000 count 4. And then she stayed.
Just double the old ones, stayed the new ones, and I figure you guys will figure it out. Or at least it'll take them a few minutes to get out. You're welcome. Oh, is this Mr. Eduardo Barrios? Thank you very much. Is this Mr. Maurice Brown?
Yes, ma'am.
Okay, thank you. Okay, sir. We have a case number 2021 CF 5694, Division 19. Public defender is appointed. Now, when you get a petty theft, but you have got 2 priors, they can file it as a felony. That's what they're seeking to do, even though it was laundry detergent. But it does appear that you've got some criminal history also. I'll stay the bond at $1,000 on that, but appoint a public defender.
Your Honor, he does have reporting requirements. He has.
A reporting requirement. Sir, do you know what she's talking about?
Yeah.
Okay.
What
So
is that again?
a reporting requirement?
Yeah, I know what it is.
Whenever you get arrested, you have to make a report.
Your Honor, can I also request a no return?
And probably that store has a trespass warning, so don't return there. All right? Good luck. Reynaldo Cosmetores? Okay, thank you. This, case number 2021, CF 5720, Division 19. It was a warrant signed by another judge who found probable cause, and we can appoint the public defender. And the bond amount on the possession of cocaine, count 1 is 1,000. The possession of drug paraphernalia is count 2 at 100. Was that it? That was it, right?
Yes, Your Honor.
A lot of paperwork. It was allegedly from May 15th, the warrant. Okay, good luck.
Your Honor, can I request no drugs or alcohol without a valid prescription?
No drugs or alcohol without a prescription. Mr. Duhart?
Bonded, Your Honor.
Thank you.
Case also bonded.
Thank you. So this might be Mr. Trenton?
Yes, ma'am.
Howard.
Did they bond? Oh, okay. Do y'all want to call him back? Or do you, oh, and it was a warrant arrest also.
I'll waive the appearance, Your Honor.
Okay, now, he didn't fill out a public defender form, but we'll go ahead and appoint him to the public defender. And let's see if so Judge Georgian put that at none until IAs.
Your Honor, I just ask that you take into consideration that my client has no valid driver's license. That was his last conviction in 2014 when setting the bond amounts.
I would also point that he did have a prior failure to appear in 2020, which was rather recent, and it looks like his behavior is escalating as he's now picking up firearm charges when he previously has been arrested for violations of injunctions for domestic violence. So I fear for the public safety as well as the victims in those cases, since he's now resorting to firearm offenses.
And I would just point out there's no convictions, Your Honor.
Okay, let me look at it for a second. Strange. Okay, so there's, all right, so we'll appoint a public defender, waive his appearance. So what, actually, I guess the first appearance sheet has 2,500 because that's the standard bond amount right now, even though it was not on the judge's warrant.
That's for the concealed firearm, Your Honor.
Oh, the concealed, oh, okay, so he's, wait a minute. Okay, carrying concealed firearm is 2021 CF 5699. And the warrant case is 2021 CF 5723. Okay, so probably the same gun. All right. In regard to the aggravated assault with a firearm, the 5723, there's no contact with the alleged victim, no return back to that store. There might have been two victims. Any of the witnesses or the victims. Let's put that at 5,000. Leave the carrying concealed firearm at the 2,500. Appoint the public defender.
And no weapons or firearms in each case, Your Honor?
No weapons or firearms, and those need to be surrendered to the arresting law enforcement agency within 24 hours of release. Is this Mr. Jimenez Munoz? Thank you. Is this Mr. Macias?
Yes, Your Honor.
Okay, thank you. Okay, sir. We have an allegation of battery law enforcement officer resisting an officer without violence in case number 2021 CF 570180, Division 17. We'll appoint the public defender to represent you. And hopefully they've been able to interview you because they had a little bit of a problem getting your identification cleared up?
Yeah, I haven't seen my public defender, Your Honor.
Okay. Uh, Okay.
Excuse me, Your Honor, do you mind if I speak?
Well, sir, you are at severe risk of accidentally incriminating yourself. There's a public defender right next to you. So if you want to mute the microphone and ask her something, that's okay. Did you get any? So you don't know of any criminal history?
He does, Your Honor.
Not?
No, he does have history.
Okay. There just wasn't much on the
He has out-of-state history.
out of state. It wasn't clear when, because this sheet here, you didn't have it by then, I guess. So for Mr. Macias? Okay, she's gonna print something out.
I'm sorry.
Ms. Howard, you gonna say something?
Does he qualify for, would he qualify for pretrial release?
I live here in Florida, Your Honor. I just moved out here. I was just wondering, I've never been in a situation like this. If I could possibly get our reward and just go home with my family tonight. The judgment is up to you.
All right, well,
I don't have.
the pretrial release people run your criminal history. They didn't have it all complete when they printed out the sheets that we're all working from. So she's looking at it again, okay? And we make a large part of our decision based on that. Whether or not you've been in trouble before, how many times, whether it's likely that you're going to be in trouble again if we let you out. So she's printing out some information for us.
Yes, Your Honor.
Your Honor, regarding the defendant's request for ROR, state would object, and I don't believe he otherwise qualifies due to this being a violent offense.
Okay, I'm still, we're pulling up the criminal history from the other state, I think. If there's some, she said there might be some. Thank you for doing that. Okay, so counsel, I'm assuming you, she's got another updated sheet.
I haven't seen it, Your Honor.
Would you all like to see it?
Can I approach pretrial?
Uh-huh. I don't know how many DUIs there are here. But, oh, you got it from there, okay.
Your Honor, it appears to be at least 2, at least convictions. As well as other violent offenses. State would just ask that you stay the bonds as set.
Okay. Sir, we're definitely going to appoint a public defender for you. They probably doubled it because of the out-of-state address. And he's 26.
Your Honor, would you be willing to lower the bond amount, the $5,000 bond amount in this case? Being that my client just moved here and he's trying to get established.
Yes, although I don't have real clear information other than what he said. He said he's been here, looks like for a couple months maybe.
Yeah, sure.
All right. It doesn't look like a huge risk of him not coming back to court. So let's go ahead and put the Batley at 2,500 and the resisting at 150. And so, sir, you're getting to the point where your criminal history is making an impact. It's up to you what you do about that in the future. Make sure you come back to court for all your court dates. State's probably going to ask for a requirement of no alcohol based upon your background and the general tendency to assume that that is fueling part of the problem. And I don't have any other help to provide you right now, but if you need Alcoholics Anonymous, they sometimes can help for free.
Your Honor, state would ask for no alcohol, no weapons, and no contact.
No contact with the witnesses and weapons, is that usually on a Bat Leo charge?
Yes, Your Honor, he has prior weapon history, as well as it just being a felony of a violent nature.
Okay.
That was when I was, do you mind if I?
Well, don't worry about it, just start to chill out, because otherwise you'll be seeing people like me more regularly. Your history's starting to
I
hurt you.
understand, Your Honor, and as this, you know, I'm not gonna speak about my case.
Don't speak about your
now.
case.
That's here nor there, but I was wondering with this bond, it seems like I have to have like a collateral or something to put down to be able to pay that. Like, you know, to be able to actually leave, like I would have to.
So you're like 26, right?
Yes.
You don't want to call your parents for help, but that's the situation you're in right now. And you need to get control of your alcohol problem. It's not up to me to make it easier for you right now. It's up to me to try to make an impact on you, because we don't need your repeat business.
No.
So I already reduced it, and that's all I'm going to do.
Yes, Your Honor.
Good luck.
Thank you.
Okay. Ms. McConnell? All right, okay. We have failure to appear on a case, number 2020-CF11249AO. It's in Division 20. We got two charges here. Okay, yeah. So the felony case, a local felony case, was on a grand theft motor vehicle and driving with license suspended or revoked habitual. And the judge in front of whom you were supposed to appear back on April 9th set the bond at $2,500 on the grand theft auto and $1,000 on the driving with license suspended. I'm assuming you have a public defender on that. Wait. Okay.
So I have a bond?
Well, yeah, you do. You have a $2,500 and $1,000 on that one.
Does have a PD, Your Honor.
She does?
Yes.
All right, so you've got a public defender, and that's what you need to deal with probably first. Now, the other one is an out-of-county warrant from Seminole County, and that's failure to appear for scheduling conference on a felony driving without license suspended and giving a false name. And I don't have jurisdiction to change that. You came in on no bond for that one. So Seminole County puts you at no bond, all right?
Seminole's got me at no bond, but Orange County's got me at bond.
Correct. So if you bond out on Orange, then you'll get a lovely little trip over to Seminole faster to deal with that. Judge, good luck.
Are you going to appoint the PD on the Seminole case?
Do we appoint a public defender on an out-of-county case?
We sometimes do, just until she gets transported.
No, we would ask that you don't, Your Honor.
Yeah, no, that sounds a little confusing. But, you know, they'll do it over there, but she probably already has one over there. Thanks. Okay. Is this Mr. Nickerson?
Yes, ma'am.
Yes? Okay. All right, let's see, sir. It looks like you have a few things going on here. Let me see if I can weed all this out. Let's appoint the public defender first. And you had some traffic And you have this out on bond for possession of methamphetamine. And let's see, different case numbers. So 2021 CF 5698 AO is, looks like a couple of counts of possession of methamphetamine. In Division 14, and the bond was 1,000 on that. And then in case number 2021 CF 5698 AO was in Division 16, but they were the same arrest date of April 12th. And that was in relation to possession of cannabis over 20, possession of cannabis with intent, possession of drug paraphernalia.
They look like
So you got a new charge from yesterday, which is 2021 CF 5698 AO, Division 16, possession of cannabis with intent, possession of cannabis under 20, possession of controlled substance, more methamphetamine, drug paraphernalia, resisting without violence, alprazolam. So that's about 7 counts. And originally coming in on the standard bonds.
it's the same.
I guess it was a seatbelt stop. Okay, and traffic charges, driving with license suspended. All right, not an extreme amount of drugs, but an assortment while you're out of bond. And evidently, you figured out that they won't let you have your license if you're not paying your prior tickets and/or cases. Point the public defender.
Ma'am,
Be careful about talking about your cases, because you've got too many and you're really exposed.
No, I'm not talking about any kid. I just want to say this one thing.
You just want to tell me you want to get out?
One thing, Mama. It says that it was a traffic citation, but ma'am, I was never driving a vehicle.
Driving with
I got
license
unwrongfully-
suspended, you've got a suspended license. Don't talk about your case, all right?
I'm just.
You don't want to say anything about your cases. I'm promising you, you don't want to say anything. You don't even want to talk about you being there, because you help them prove one element.
Your Honor, state would request in 21 CF 5698, you stay the bonds as set. They're already treated as subsidiaries to the cannabis with intent.
It's not.
State would also request that you stay the bond in the Dwellis case and revoke his out on bonds, as he was out on bond in drug offenses, one of which is also cannabis with intent to sell, and then the other is MDMA and ecstasy. He was out on bond on drug-related offenses. A condition of being out on bond is not picking up any new offenses, and he picked up more drug offenses while out on bond for drug offenses. So state would request that you revoke those bonds.
Your Honor, I would argue that these are all nonviolent offenses, and if you look It seems that he has a nonviolent criminal history. So if you are inclined to revoke, I would just ask that you revoke and set a higher bond as opposed to revoking and holding him at no bond.
And, Your Honor, to put on record, his bondsmen already came off his bonds. They already been endorsed, so they're already added back on him. His out on bond charges.
I just make the argument that he's shown an inability to comply with court orders, Your Honor.
All right, let me see. So it looks like he's a low-level drug dealer. I mean, these are not like profound amounts, and, you know, he probably really thinks that cannabis should be legalized, even though it's not yet. So don't say anything. And, I mean, the amounts are not blowing me away, but he obviously doesn't agree with the law and is doing what he wants anyway. No problematic violent history. So, Mr. Nickerson, you know, maybe someday cannabis will be legal, but even then they'll probably, you know, you have to have your licenses and stuff to sell it. I don't know. I'm a little bit concerned about the felony judge. I'm not going to revoke it completely, but, you know, what I've always done is doubled the ones that you're out on bond for. And you already have a few. And so you're getting to the point where, you know, I don't know who's paying these bonds for you, but you don't want them to have to start mortgaging their house. And I'm going to double them, assuming you got a public defender, you can get downtown, you can figure out what they're going to do with you for carrying these small amounts of drugs. Because I don't even know what they're doing anymore on that stuff. And, but you definitely expose yourself when you get the same kind of charges again, and you're just rolling right around doing it as if it doesn't matter. You can say whatever you want, but it'll incriminate you. And I'm just going to do the best I can with it. I know you're young. You don't realize how serious this could be. So, but I'll just do the best I know how to do with it. Okay, so she's right. You're out on for 2002 1 CF 5698. The big one is your possession of cannabis with intent to sell, I think, is at 10,000. I'm going to double it to 20. So whoever bonded you out is going to be really peeved at you if you ask him again.
You said the case number for one of his new law offenses?
I did?
Yes. You said.
Oh, well, you know what?
5, 6,
You know what's
9, 8.
happening is some of those are written on the top of the page, and I'm thinking that they pertain to the old charge. I'm sorry,
No,
I've done
Your
that
Honor.
before.
If-
So the old charge is 2021 CF 4254.
Yes.
And the middle charge, count 2, is at 10. 10 is going to be at 20. I'll leave the other subsidiaries at 150 for count 1 and 100 for count 2. And in case number 21 CF 4253, I'll leave it at 1,000, just, you know, to make it easier for everybody to understand. The only thing I've doubled is cannabis, the sale, not because I care about the sale of cannabis. I mean, it's going to be legal long before you're my age. But you can't just blow off the law. You'll mess your life up. And so the new charges.
I'm sorry, just to be clear, for 21 CF 4254, you revoked. Count 1 is now 20,000. Count 2, you stayed at 150. Count 3 stayed at 100.
Right.
Okay, thank you.
Thank you. And so the new charges, 21 CF 5698, will find probable cause, stay the bond on possession of cannabis with intent to sell it, 1,000, that's count 1. And you've got all these other little charges. Count 2, possession of cannabis, 100. Count 3, possession of controlled substance, 100. Count 4, possession of methamphetamine at 150. I'm saying all those bonds. Count 5, paraphernalia at 100. 6 resisting at 100, 7 alprazolam at 150. And then the driving with license suspended, looks like you got some suspensions. That'll catch up with you too. That's 2021 CT 3567AO, and we'll stay the bond at 500 on that. I mean,
Thank you, Your Honor.
good luck, the rules
Your Honor,
apply to you.
As to 5698, can I request no drugs or alcohol without a valid prescription?
Okay.
And Your Honor, for 4253, you took no action?
Was that one of the ones he was out on bond for?
Yeah, you said the bond was already at 1,000.
Yeah.
So
No action. The only thing I doubled him on was the $10,000 one in 21 CF 5698. No.
you mean 4254?
I'm sorry, I did it again. So we had the handwritten numbers at the top of the page, and I keep looking at that. 4254, I'm sorry.
Okay, gotcha.
Correct. Thank you. Am I giving you guys a difficult time following what I'm trying to do? Maybe we can blame him for having too many charges. Okay, all right. Is this Mr.? No. Because you don't look like April. Or? Okay.
Your Honor, I'll waive the appearance.
And she's on probation also, so let's see what she's got. Let's go ahead and appoint the public defender. It's case number 2021 CF 5697AO, Division 15. Oh, I guess she just supposedly gave a false name at booking. Let's just stay the bond at 1,000. And I'm imagining she came in on something else anyway, so we don't need to take any other action. Appoint the public defender on that. Okay, are you Mr. Robert James Rita?
Rita Bondi, Your Honor.
Thank you. I think we probably confused you by now. Are you Mr. Raymond Dean Sanchez Volbrecht?
Yes, ma'am.
Okay, thank you. All right, then. So let's go ahead and appoint the public defender, Butley. Okay, so the new charge is 2021 CF 5704 in Division 10. And the only reason we're appointing the public defender is that you probably need one for initial appearances, and I don't know if you got Miss Sweet and Mr. Blanco as private attorneys or conflict lawyers, but if you get private attorneys, then you can always do that. So the new charge is a burglar of a structure. And I saw that one yet. And it looks like they got enough information to file that charge at the rate of $3,500 bond. So we'll appoint the public defender. And supposedly you're out on bond.
Can I also ask for no return to the area, no contact with victim or witnesses?
All right, no return to that site, no contact with any victim. Okay, so you got one in Osceola, that's the one you got, Attorney Blanco, and you got Dwillises. All right, Dwillises, okay, got it, okay. All right. Right, sir, I'm gonna do something on the other ones. I know what they expect in Osceola. They probably expected no bond, but Osceola County is 2020 CF 1923. I'll just double it to 6,000, although they're probably used to no bonding on those. But it's a violation of your bond conditions to get new charge. So they expect that I don't let you out easily. In regard to 2020 CF 6225, that's also a drivable license suspended habitual. Let's double that to 5,000. You've got also 2020 CF 11750 AO. Grand theft. You might have been ROR'd on that. In case you were, that was, I'm guessing that was a 33-day motion or something, but,
Yes, Your Honor, it was.
okay,
His
so
bond was previously
let's
set
take
at
no action on that
1,000.
one. But, sir, these other judges expect me to do something and not just let you out when you get a new charge. So I just hiked them.
You're taking no action as to the grand theft motor vehicle?
Right, the one that he was ROR'd one, we'll just leave that. Yeah, stayed the bond on the new case. Okay, is this Ms. Annette Stallman?
Yes, it is, Your Honor.
Okay, thank you. All right, we have on case number 2020 CF 5333 AO, a failure to appear warrant
Your Honor?
on a delivery of cocaine in Division 20, or 15, I'm sorry. Ooh, it says, Ms. Dahlman,
Yes, ma'am.
before you say anything,
Sorry.
the judge's order says, revoke bond not to be modified by first appearance judge. So that means that I'm supposed to keep my paws off of this, and that judge wants to see you back there. But we'll appoint the public defender.
So you're holding her no bond, Your Honor?
Yes. Is this Mr. Velez Santiago? Okay, thank you. Just trying to barcode this. This is case number 2020 CF 7755 AO and 2021 CF 5705 AO. The new charge is a possession of controlled substance in Division 11. Let's appoint the public defender. Find probable cause and set the bond at $1,000 on that. In regard to the old case, 2020 CF 7755, that's Division 19. It was an alleged failure to appear on a possession of cocaine, originally coming in no bond by that judge. And it says no bond pending hearing before the court, so that judge wants you to come back to them instead of me doing anything with it. So we'll give you the public defender on both, and they'll just try to expedite all of it in front of one judge.
Your Honor, on the 5705, can you order no drugs or alcohol without a valid prescription?
No drugs or alcohol without prescriptions. Okay. You want us to set these aside? There's only a few more. You want to do the refused court afterwards?
Yes, Your Honor, that's.
Okay, we'll get these folks through the line. So is this Mr. Cornelius Williams?
Yes, ma'am.
Thank you, sir.
You're welcome.
We have case numbers 2021 CF 5689. I guess the one case number is the new case, and then you might be out on bond for possession of cocaine in 2021 CF 4513. And trespass 2021 MM 2662AO. Right. Let me just look at it real quickly. All right, the new case. Let's make sure we appoint the public defender on everything. And I'm looking for the new case. Is it in here? Has he got a new case, 5689?
Yes, Your Honor, of cocaine and cannabis.
Okay, unless oh wait, it just was not attached with the same paper clip, so I didn't find it. So 5689 and also 5706. Okay, so 5706 is coded to Division 15. Let's appoint the public defender.
Your Honor, 5706 is a different Mr. Williams.
Oh, that's a different Mr. So, you know, I don't seem to have the paperwork on 5689 for Mr. Cornelius Williams. It should be right there? Well, I've got under the out on bond? Oh, it's not, it's, okay, it's this one sheet here. Okay, thank you. I'm not used to them being stapled, I guess. Thank you. All right, as to the 2002-1 CF 5689, it's going to Division 10. It's coming in at $1,000 on the cocaine and $250 on the cannabis, but the cannabis could be $100 probably. And it looks like they have probable cause for a number of pieces. Okay. And then he's out on bond.
Your Honor, so are you setting count 2 at 100?
Well, yeah. Although he's got a few pieces, I don't know how large they are. If they were significant, they would have upped it. Well, stay count 1 at 1,000, put count 2 at 100. As far as the possession of cocaine that you were out on bond for, 2021 CF 4513. Not seeing a whole lot of history on the pretrial sheet.
Your Honor, since they're nonviolent offenses, I would just ask that you take no action on the out on bond.
Your Honor, he has a significant drug history.
Okay, maybe they didn't have that printed up at the time. How about we double those? Because I think the felony judges expected, and he had a number of pieces on the new one, so there's a concern that he's not. Oh, there's the history. The history is on this other sheet. Oh, yes. All right, we'll at the very least double it on case number 2021 CF 4513 from 1,000 to 2,000, and the trespass case 2002 1MM 2662 from 500 to 1,000. That's in Division 81. Sir, you probably have cases in at least 3 different courts right now. we'll appoint the public defender on all of them, but you need to manage the different court dates. And I think I've been a little bit generous because I didn't pay enough attention to looking at your criminal history when I first saw it. So I don't want anything I did today to give you the impression that it's always going to go this light, because there does come a point where you just get stuck in here.
No.
All right, good luck. Okay. Is this Fontavious Williams?
Ma'am.
Okay. Thank you, sir. Okay, let's see here. We can appoint the public defender. We've got 21 CF 5706. And here's the history. So this charge alleges possession of firearm and commission of felony, and then another count of possession of firearm, and then possession of ammunition and methamphetamine, and cannabis. So you've got 6 total charges. Okay, looks like they have probable cause, sir. So we're appointing the public defender on all of them. And these came in with the normal bonds amounts, I think, for the initial charges, but are we still doing subsidiaries on the subsequent charges under count 1?
Generally not on firearm charges, Your Honor.
But the drug charges, yes?
Yes, Your Honor. Well, the meth and the cannabis, yes, Your Honor.
That and what?
The sole possession of methamphetamine, count 4, and count 6, the cannabis.
Okay.
Not 5, because it's the meth with a weapon.
All right, so, and he's got a little bit of history. I'm okay with the 2 possession of firearms, stay in those, but the ammunition, I'll probably make that a subsidiary also. All right, so, sir, the reason I'm asking the state is I'm basically a substitute retired judge, so I'm going along with what they do normally. So on count 1, the possession of firearm and commission of felony, it'd be 5,000. Count 2, possession of firearm by convicted felon, it'd be 4,000. The other 2 felonies, 3 felonies, possession of ammunition by convicted felon, possession of methamphetamine, count 4, possession of, methamphetamine with a weapon is sort of a duplicate. Let's put those at 150 each. That's for count 3, 4, and 5. And then for cannabis, that would be $100. Subsidiary bonds for the add-on charges, basically. And we'll appoint the public defender. Good luck.
Your Honor, can I ask for no drugs or alcohol without a valid prescription and no weapons?
Okay, we'll order those things also.
I would just ask no drugs. I know it's alcohol.
Okay.
Standard on the form. Just both.
Is this Mr. Ellis?
Yes, ma'am.
Okay. All right, Mr. Ellis. So this came in as a violation of probation warrant. Generally speaking, I have always ended up appointing a public defender and just telling you what the allegations are, because the felony violation of probation judges don't want me touching their bonds. Okay?
It's like a violation, it's the misdemeanor charge that they're trying to put on me.
Well, you don't want to admit to anything, so be careful about saying anything. Let's see what we got here. So, yeah, you got a new charge of cannabis, and that is on case number 2002-1MM3332. we'll appoint the public defender on that also. Oh, the dark tint, okay. Yeah. All right, well, Mr. Ellis,
Ma'am, excuse me.
so be careful. I know you want to tell me that you're not a bad guy, and I'll tell you the truth. I don't care about cannabis, but the truth is, when you're on probation, you can't do anything. And you are really kind of up a creek if you're on probation.
Yes, ma'am, but I was riding with somebody, it wasn't my vehicle.
I know, it's not your vehicle. Let me see where they said they found that. Okay, supposedly not located under your behind. So that, you'll talk to your lawyer about that. All right? But here's the real concern I have as somebody who's old enough to be your grandmother, okay? You can't be driving like this guy that just got charged with all these, he was carrying a whole pharmacy, supposedly, of different things in there, and you're on probation. You can't do that. So you can argue with the judge later about who put the supposed cannabis under your bottom, but, now you're in trouble because you were on probation. You just can't. I can't help you here, right? You're going to have to sit there, get in the public defender and argue about whether it was your cannabis or not. And maybe they won't hit you too badly because you might not have much of it. Well, you do have a bit of a criminal record. So, so the case that he's on probation on is this, it's a 2002-1-162-323, Division 17. So those generally come in no bond. I'm going to appoint the public defender. I think they will get to you fairly quickly on that, so you're going to know what the damage is. You just don't have any slack when you're on probation. You have like zero.
Your Honor,
I've seen people go to prison because they had a little pie on them because they were on probation. That does happen.
So that's what I'm looking at, going to prison for.
Well, no, I'm not saying you are absolutely, but I'm saying that you're at risk. It's like you're on a ledge and you're fixing to step off on it. I don't know if you already stepped over the edge or not. But when you're on probation, you can't be riding around with people with drugs in their car. You just can't. Okay? It's not worth even thinking about sending you to prison for that. That's crazy. But that's why you put yourself in that position. It actually breaks my heart. I hope you turn stuff around.
Thank you.
You're welcome.
you say the bond on the cannabis at $250?
Oh, yeah. What a waste.
No bond on the VLP?
Yeah.
Thank you, Your Honor.
Oh, my. Oh, and that's let's put that one behind because we got one more person left and we got two people that we're going to talk about who aren't here. Or we got two more people left in line, I guess, maybe. Not very many. Is this Ms. Moore? Okay. Ms. Moore, we have an alleged violation of probation on 2020 CF 6629AO, and I think a new charge on 2021 MO 3328, an alleged resisting. Let me look at that real quick, and we'll appoint the public defender on everything. The resisting is going to Division 61. Okay, so they have enough information to file that resisting. We'll stay the bond at 500 on that. And they were trying to arrest you on a violation of probation on a carrying concealed firearm, possession of controlled substance charge. That's 2020 CF 6629 in Division 20. And that was coming in at no bond. Ma'am, I can't really touch that, but you will be seeing, I guess I was carrying concealed firearm, possession of controlled substance, possession of drug paraphernalia, and maybe if there were more charges on that, they're on the next page that did not get printed, but I think you know maybe what I'm talking about. So if you're on probation, just like I told that young man a moment ago, I can't do anything here other than just give you a public defender and tell you that you're going to that other judge pretty soon, and you've got to be very careful.
You said pretty soon, in a few days or so?
Well, you know, I haven't been sitting over here in the jail for, I don't know, about 7 years now, but back then, it was pretty quick. I don't know what exactly they're doing. I think they try to do those fairly quickly. Does anybody know? About a week. She says about a week. The clerk knows. All right. Okay, is this Mr. Anthony? Okay, thank you, sir. This is an out-of-county warrant, I believe. All right, and these are charges from the year 2017, CF 2031. I think. Wait, let's see. He's got more than one thing. Okay, so out-of-county warrants on the 2017 case 2031 were at no bond in regard to failure to appear on a burglary with a criminal mischief and a grand theft. Let me just make sure I've got everything here because we've got different pages. And normally, okay, 2031, it's duplicated, it's the same thing, I think. Do we only have one? Okay, only one Osceola County charge. And then there is a 2020 CF 9791 in Division 22, which I think is going to be in Orange County. Burglary of a structure while wearing a mask and criminal mischief. Oh, okay, so he's been picked up on a 2007 while he's out on bond on a 2020?
Yes, Your Honor,
So
due to
we
that
don't,
last
I
year,
don't
we take
think
no
we
action.
need to do anything with the 2020, do we?
No, Your Honor.
All right.
Yeah.
Do you want to talk to the lawyer first because you might say something about your case and you don't want to say that on the record?
I advised him of that, Your Honor, however, he still wishes to speak with you.
You know, I'm not going to do anything.
Sorry, but it's a true mistake. I had court on the same day for Orange and Osceola, and I have proof of that. And my mom couldn't even come because y'all.
Sir, I can't hear you either. Is it something that you can interpret it for me? Because
Yes, Your Honor. He stated that he had court on the same day in Osceola and Orange County.
And I can't.
okay, well, that, you
And he
know,
came to one, Your Honor.
sure, you know, that's a possibility, but I can't tell that from here. You would think I probably could just look it up. And if any of these lawyers tell me that, confirm it, that's okay, but even then, I don't like messing with other judges' bonds because they get really aggravated when I do that. I have had so many, you know, almost every time I've ever done that, I've heard from the judge. So here's the thing. Even if it was the situation, it might be the situation, and you've told this public defender, and you're going to tell the next public defender, either one of them is going to try to check that out, all right? Number one. So it'll be checked out. You're not going to be in there forever over that situation. Number two, Osceola's going to come and pick you up right away because they're right next door and they come, you know, they used to come every day. I don't know if they still come every day, but I don't think it'll take very long. And here's number three. You don't want to be having so many cases that you have those kinds of mix-ups. It's up to you to not have so many cases.
Yes,
And
ma'am.
also to keep your lawyers informed, because if they're informed, then they can tell the judge about the conflict. So there are ways to manage this in the future, even if that's exactly what happened. And number five, it's quite possible that you mixed up the court date. So I'm not going to second guess what happened. I'm going to let you go through the procedures and hopefully learn how to better manage your cases, in particular by not getting any more cases.
Yes, I just have so much going on because I can't go to trial because my incompetency. And I would love it. I
Well, let me
handle
tell
all
you
my
something.
stuff.
Everybody in here has got those problems, and I'm trying to get you to stop getting any more cases.
Your Honor, on another issue, he was actually the victim in a domestic violence case that we saw this morning, Miss Leaks Brianna, and they did want contact, and he wanted to testify here today that he wanted contact with her.
Your Honor, I would just ask that it be handled in the trial division.
I never pressed charges on her or even asked for that to happen.
Your Honor, given the...
But is it possible you could write something out and give it to your attorney so she could file it in that case? Because it's complicated right now. She's not here. I think what your lawyer's asking me to do is to change her release conditions.
Yes, she was the alleged, she was the defendant. He's the alleged victim, Your Honor, but they want contact with each other. I already spoke with my client. She wants contact with him. We did not know that he was arrested for these out-of-county warrants at the exact same time.
Yeah.
And so we were just asking if you would allow contact, being that he wants to have contact with her. No hostile contact order.
We probably gave her a release condition that's going to allow her to get out, right?
Yes, Your Honor.
Okay, so they both need to talk to their public defenders. They're going to end up with she's going to end up with a conflict attorney. And it could be easily filed that, you know, their written desires to have contact, and whoever is representing them ought to get them in court like fairly quickly, within a few days. But I'm just reluctant to do anything that now the paperwork's gone. The state's going to object. The clerk doesn't want to deal with it. And I know that there's a procedure and to get it done pretty quickly. Although I don't know if your friends downtown are going to do it fast. I know there's a process for that. All right.
I had one last question. There's no possible way you could search up my case number and see when that I have court on the same day as Osceola?
Well, remember that I was telling you number 1 and 2 and 3 and 4? I still have the same answer for you. I want you to stop getting multiple charges that are hanging out there at the same time, number 1.
Can't get rid of
And
my
number
charges.
2, your lawyers are going to figure it out, and if that's what happened, you know, they'll get some accommodation for you, but you really want to avoid having multiple charges. And God forbid that should ever happen. Even while it is happening, you need to be in very good contact with your lawyers so they can maneuver around that.
Can't go to trial for it because I'm.
Your Honor, I will let the attorney assign though that he is being held at no bond, and then we will try to get you in to see the judge as quick as possible.
Yeah, you'll be in front of the Osceola judge real quickly. The biggest problem is you got too many charges to manage.
Since 2014, I've been coming to jail because I could never get my charges dealt with. I never went to a program since I was young.
Well, the 2 charges we have right now are 2017 and 2020, so,
Osceola?
yeah, Osceola is 2017, sir. Good luck. All right, so we have 2 people who were unable to make it. And I think we can deal with that without anybody having to wait in line for that. And one of them was Kiera Wilkerson. Thank you. Okay. She's got a multitude of cases here. So let's appoint public defender.
Probably better just to go in order.
Was that a question?
No, I said it's probably better just to go in order since there are so many.
That mask is confounding me. I can't hear your words.
Oh, really? I said it's probably just better to go in order since there are so many.
Do them in order. Okay, thanks. Yeah. Okay, she's got 2021 CF 4966, and that is in Division 12, and that is a warrant in regard to burglary, unoccupied dwelling, unarmed, and grand theft larceny, allegedly 28 of April. And another judge did find probable cause for that and did set bond at count 1, burglary at 3,500, count 2, 150. We'll stay that. Total is 3,650 for the 2 charges on that.
Your Honor, they asked for no return and no contact.
No return to this scene, no contact with any alleged victims. Okay, thank you. Okay, then there is 2021 CF 4966. I don't know if I'm supposed to barcode every one, but that's another arrest warrant, I believe.
Your Honor, that's the one we just dealt with, 496.
Thank you. 2020 CT 2566 is a failure to appear on a driving while license suspended. The bond is 2,000 and it's in Division 85. We'll stay the bond. There's another case, 2021 MM 92 AE, which is in Division 83 currently. We'll appoint the public defender. The allegation is false ID to law enforcement officer. Okay, they have probable cause for false ID given to a law enforcement officer in case number 2002-1MM92A3, Division 83, public defender appointed, bond stayed at 500. And then I think they gave her another one. There's a 2021 MM92AE, and there's a 2021 MM93AE. So I guess they gave her 2 charges because it was 2 officers?
Your Honor, I guess, or the officer just hit submit twice. I'll just ask that you ROR as to 21 MM93 as it is the same
All
offense.
right, let's go ahead and ROR her on that. All right, and then the traffic charges are in regard to the driving while license suspended, and that's going to Division 62, and those are 2021 CT 475 AE, 476 AE. So we got driving while license suspended and failure to register. They did have probable cause for those. And the driving while license suspended is at 500 and the failure to register is at 100. So I think we got them all, right? Do you deal with these? I've been giving them back to you. Let me know if there's something I need to do differently then. Okay. Trevor Howell is the last one. It's a felony warrant VOP, and I think he was unable to come, medical or something?
Hospital.
Hospital, okay. It was an on-view VOP in regard to case 2018 CF 8018, Division 22. And they have it at 1,000. A sheet on the front? For the, oh, the on-view for the 0. Okay, well, because, all right. Let me read it. Right, okay. All right, looks like they got enough. Okay. So the resisting charge is 2021 MM 3366 AO. It's in Division 84. We'll appoint the public defender, stay the bond at 500. And in regard to the VOP, based upon the resisting, which is the 2018 CF 8018 AO, it's Division 22, well, probably the assumption is that no bond, and he'll see the VOP adjudged quickly, and we'll appoint the public defender on that. Anything else?
Nothing from the state, Your Honor.
All right, thank you all very much for everything, and we will be in recess.